have the consent of the opposite party. I need 2 weeks time for some clarity.
Item 17.
17 of the hearing list, Lordship.
Item 17 at the request of MS S. Zimomi, Z. Zimomi, counsel appearing for the respondents. Matter stands adjourned for 2 weeks.
2 weeks, Lordship.
It is submitted that consent of the counsel for petitioner has been obtained. Placed accordingly after 2 weeks.
Obliged, Lordship.
May it please, my lord. Lordship, I may be allowed to make a mention for hearing item 43 from the supplementary list.
Yes.
I have taken the consent of the opposite counsel, Lordship. I am for the private respondent. If it can kindly be listed after 2 weeks.
Item 43 at the
43, my lord.
of Mr. Sendi Anwell and a counsel for respondent number
5.
5. Stands adjourned to be listed after 2 weeks.
Yes, my lord.
It is submitted that consent of the counsel for the petitioner has also been obtained. Placed accordingly.
Much obliged, Lord.
Yes.
Lordship, I beg to mention item number 12.
Well,
I'm yet to receive the instruction. So I may be allowed 3 weeks time.
item 12 with the request of learned government advocate matter stands deferred to be listed after 3 weeks. So
No
the
objection.
petitioner does not object to the prayer. Yes.
Yeah, please, Your Lordship. Your Lordship, I'd like to mention item 34, Your Lordship.
Yes.
This matter may be listed after a week, Your Lordship.
Petitioner,
I have no objection, Lordship.
item 34, the request of learned government advocate. Stands adjourned for 3 weeks. Prayer not objected to by counsel for the petitioner. Yes.
Your Lordship, I also beg to mention item 18 to 27, Your Lordship. Your Lordship, here, I need some time to prepare, Your Lordship. So it may be listed on Thursday, on 14.
Yes.
Thursday, we have a lot of matters, right?
Your Lordship,
How many matters on Thursday?
8 matters, my lord.
22.
These are for hearing matters.
Yes, Your Lordship. On 21, Your Lordship, then.
Right. 18 to
18 to 27.
what are these matters otherwise?
They're praying for minimum scale of pay, Your Lordship.
Minimum scale.
Yes.
Yes, Your Lordship.
Is there any office memorandum here?
No, Your Lordship, as of now, no, Your Lordship.
All right, 18 to 20.
18 to 27.
Huh?
18,
27.
yes, Lordship.
List after 3 weeks at the request of counsel for the respondents.
Much obliged.
Prayer
Lordship.
not objected to by counsel for the petition.
Obliged.
May I please, Your Lordship?
Yeah.
Your Lordship, I beg to mention item number 3. Your Lordship, may kindly allow me 3 weeks time to file my reply.
Item 3,
Yes, Your Lordship.
not just now, wait. Just wait for your turn, yes.
Please, Your Lordship. Lordship, I beg to mention item 9 on behalf of S. Chang, Government Advocate. We pray for 3 weeks to file our affidavit in opposition, Your Lordship.
Right, item 9. At the request of learned counsel for the respondents and adjourn for 3 weeks. All right, we'll give you
Obliged.
item 3, come. What is your prayer?
Your Lordship, may allow me 3 weeks time to file my reply.
3 weeks.
Yours.
3 weeks time sought for by the counsel for petitioner to file reply. Prayer not objected to by government counsel, prayer allowed. List after 3 weeks.
Obliged, my Lord.
Yes.
May I please, Your Lordship? I beg to mention item number 32. Kindly this matter may be listed after 2 weeks.
22.
32, Your Lordship.
32 after
2 weeks, Your Lordship.
2 weeks.
Yeah.
You're for the
Private respondents, Your Lordship.
private respondent. Any objection?
Your Lordship, Your Lordship may fix the date, since this is a fixed item.
After 3 weeks on a date to be fixed by the registry. Prayer not objected to by the counsel for the petitioner. Yes.
Which one?
Much obliged.
Like this, Your Lordship. I beg to mention item number 36, 37, and 38. Your Lordship, kindly list this matter on 21/11/2024.
36, 37, 38.
Yes, Your Lordship.
You're for the petitioner.
Yes, Your Lordship.
Matter stands deferred to be listed in the week. Listed on 21st.
Yes, Your Lordship.
Any objection?
No, Your Lordship.
No objection by the government counsel. List on 21st.
Obliged.
Please, Lordship. Lordship, I beg to mention item number 10, Your Lordship. I'm for the respondents in this matter. I have received the Paraguay's comments, Your Worship. I may require 3 weeks' time to file my affidavit of
What
opposition.
is this matter? What is this matter?
It's a new, I've recently got the matter, Your Worship.
Lordship is challenging the proceeding and impending order passed by the respondents, which is in violation of the statutory laws.
Who are the respondents?
Respondents are the Assistant Commissioners, the Union of India, the GST councils.
GST matter.
Yes, GST.
Item 10, the request of standing council for GST. You're Mr.
That could,
Z. Kulnu. Appearing for the GST, prays for 3 weeks' time to file, complete his instructions and file necessary affidavit. Prayer made is not objected to by the council.
Lordship, yes, interim.
Interim order passed earlier, if any, will continue.
much obliged.
Much obliged.
May I please, my lord. Lordship, item number 15 and 16. 15, 16, Lordship. Lordship, can you list the matter after 1 week? I'm submitting, mentioning on behalf of my colleague, MS Livika. She has some difficulty today. One.
Item 15 and 16, yes. Any objection?
No, Lordship. Lordship, the inquiry is still pending, so maybe more than, it may need more than 1 week.
You are seeking a deferment beyond 1 week.
Lordship, it's pending before the district judge, so
Item 15, 16 at the joint request be listed after 2 weeks.
Lordship, obliged.
In item number 6. 15, Lordship, my name is been reflected for respondent number 4, 5, and 9, Lordship.
Yes.
I'm no more appearing in this case, Lordship, so my name will be listed.
Mr. N. Mozoi, Learned Counsel, submits that his name appears for respondent 4, 5, and 9, which he does not represent as on date.
Lordship.
Registry is directed to strike off the name of Mr. N. Mozoi from the course list.
Lordship.
And Mr. Mozoi is permitted to file necessary applications.
Lordship.
Have you filed a wakalat earlier?
No, Lordship, I am the standing counsel for the
Standing
Vigilance
counsel.
Commission, yes.
You filed a memo of appearances earlier. You filed an application that you are no longer appearing.
Lordship, I'll do that.
For the registry.
Obliged, Lordship.
Obliged.
Please, Your Lordship. Your Lordship, I beg to mention item 8, Your Lordship. Here, Your Lordship, I filed the counter yesterday, but I'm yet to serve a copy to the petitioner because the petitioner is not available in the court premises. So this matter may be listed after 3 weeks. In the meantime, I will serve a copy to the petitioner.
Right, 3 weeks, you have already filed it.
Yes, Your Lordship, but
1 week, 2 weeks, no. 2 weeks.
because I'm yet to serve a copy.
You're appearing?
Yes, Your Lordship.
She's here, you serve a copy.
I filed today. Yes, sir.
Learned Counsel for Government Advocate submits that the affidavit has been filed today.
Yesterday. I mean.
A copy of the same has not been served on the counsel for the petitioner yet. So counsel for the petitioner on the other end submits that since the affidavit has already been filed, she would require 2 weeks' time to complete her instructions and file necessary reply if so advised, list after 2 weeks.
Much obliged, Your Lordship.
Yes, Your Lordship. Lordship, I would like to mention item number 6.
Yes,
Your Lordship, we are yet to file our reply. Kindly grant us 1 week time, Your Lordship.
yes, any objection?
No, my lord.
Item 6 at the request of counsel for petitioner, list after 2 weeks, enabling them to file reply affidavit. Prayer is not objected to by the government council, they stick accordingly.
Obliged.
May I please, Your Lordship? I'm appearing on behalf of counsel for the petitioner. Your Lordship, since sorry, Your Lordship, I beg to mention item number 28, 29, 30, 31.
28, 29, 30, 31.
Your
Yes,
Your Lordship, since counsel for the petitioner is out of station due to some urgent work, I pray that the matter be listed after a week.
yes.
Lordship, no objection.
At the prayer of counsel for petitioner, matter differs, is deferred to be listed after 1 week. Prayer not objected to by the counsel for the government, list accordingly.
Much obliged, Your Lordship.
May it please, Your Lordship. Lordship, I beg to mention item 13 on behalf of Young Gauhati CJC. Lordship, we are yet to receive the signed copy of our affidavit, so kindly grant us 2 weeks' time.
Yes, item 13.
We have no objection, Your Lordship.
Item 13, mention is made on behalf of the learned CKC. Seeking further time to file affidavit.
We're yet to receive our signed copy of our affidavit.
Signed copy of what? Instructions?
Yes,
Affidavit.
instruction, yes.
Lordship, this is a contract matter, so if I've already filed my affidavit, Lordship, and served to all the parties also, Lordship, so if an interview can be made to dispose the matter on the next day, otherwise, as per the last order, an interview was to be made today, Lordship, for disposal, but it's alright since they are waiting their instruction.
It is deferred at the request of learned CKC to be listed after 2 weeks.
Yes, Lordship.
Yes, Your Lordship.
Weeks. The respondents may file their necessary affidavits in the meantime. Respondent number
4.
4. Counsel for respondent 4 submit. He has already filed the affidavit.
Yes, my lord.
Prayer made is not objected to by the counsel for the petitioner. List accordingly.
Lordship, if an order can be passed to make an interview, Lordship, to dispose on the next day.
He was already there, as you say, but you are agreeing to the adjournment. The endeavor should be made to dispose of the writ petition on the next 8 weeks.
Much obliged, Lordship.
From the supplementary cost list for withdrawal, item number 39.
May it please, my lord. Lordship, here there's been some subsequent developments and the parties, they wish to resolve the matter outside the court. So if I may be given the liberty to withdraw this writ petition.
Learned counsel appearing for the petitioner on instruction submits that an attempt is made between the parties to resolve the dispute outside court. Therefore, he has been instructed to withdraw the writ petition for the present. Accordingly, writ petition stands dismissed on withdrawal. Interim orders, if any, stands vacated. Pending IS are also dismissed. With liberty.
Lordship,
And the MS so-and-so appears for the government.
Lordship.
I'm deeply obliged.
Writ petition dismissed on withdrawal with liberty.
For motion, item number 40.
Your Lordship, this is a petition pertaining to appointment of land ownership basis, Your Lordship. Your Lordship, in the year 21 to 1964, an agreement was executed between the government of Nagaland and the Chin and Mon village. The agreement is annexed here as Annexure B, page number 19, 20, and 21, Your Lordship. Subsequently, an MOU was agreed between the parties in the year 25 to 2015, since the landowners were not given land tax as agreed. The MOU is annexed here as Annexure C, page 22, Your Lordship. Your Lordship, again on 5/6/2024, another MOA was executed by the landowners of the Chin and Mon village and the government. The MOA is annexed here as Annexure D, page 23, Your Lordship, wherein it is provided that 49.5% reservation will be given for Chin and Mon landowners in the appointment to a grade 4 post, Your Lordship. However, without considering the MOA, the respondent number 5 was approved for appointment by the government by impugned order dated 15/9/2024. The impugned letter dated 15/9/2024 is annexed here as Annexure F.
Where is the first MOU?
MOU is annexed here as Annexure C,
Page number?
page number 22.
22.
Yes.
No, what was the agreement first? Page number 20, what is that?
The first agreement was in the year 21 to 1964, Your Lordship.
This is
It's
for,
annexed,
this is for,
page number 19, 20, and 21.
Then 22 is a subsequent agreement.
Subsequently, an MOU was executed between the parties on 25/2/2015, Your Lordship. Then after, again on 5/6/2024, another MOA was executed by the landowners of Chin and Mon Village and the government, Your Lordship. The MOA is annexed here as Annex D, page 23, Your Lordship.
And what provision are you claiming? The appointment, is there any government?
Yes, Your
circular
Lordship.
notification?
Yes, Your Lordship. The page number 17, Annexure A, MOU for the notification dated 5 March 2018, Your Lordship. In the notification, it is.
Who's for the respondent? Any submissions?
Your Lordship, at this stage, notice may be issued because we have a private respondent here.
Heard, Senate Counsel for the petitioner. So and so, Mr. So and so for the government. This petition is filed by the petitioner seeking appointment. Which post are you seeking appointment?
Grade 4 post, Your Lordship.
Grade 4 post under the establishment of home guards. Under which grade 4 post where? Which department?
District Commandant
District
and Home
Command-
Guards.
District Commandant, Home Guard, Civil Defense and State Disaster Response Force. Mon, Nagaland. Stop. Then the council to the petitioner refers to an agreement, agreements executed by and between the Chi and Mon village. Chi and Mon village, who executed on their behalf, the elders?
Yes, Your Lordship.
Chi and Mon village elders. Village
Angs
elders,
and Kamburas and the elders of the village.
sorry,
Angs and Kamburas and the elders of the village.
Angs, ANGS. Angs and ANGHS. Angs, Gamburas and elders of Chi and Mon village. With the district administration led by the DC Mon. Whereby preference, whereby inter alia it was agreed that preference shall be given to Chi and Mon village for appointment of grade 4 staff to the government departments falling under the Mon headquarters. Stop. This agreement came to be executed by, in view of the land allotted by the Angs and Gaumburas and elders of Chi and Mon village in the district of Mon for establishment of government departments, including the Office of the District Commandant, Home Guards, Civil Defense and State Disaster Response Force. The council for the petitioner submits the note extending this agreement. Who is appointed? Some person is appointed,
Yes, Your Lordship.
the respondent 5.
Yes, Your Lordship.
He is appointed as what? Grade 4.
Yes, sir. Yes, Your Lordship.
Where is that order?
15/9/2000.
Page number?
2024. Page number 27 and 28, Your Lordship.
Notwithstanding that, the Undersecretary to the Government of Nagaland issued an order dated 15th of September 2024, whereby several persons were appointed as grade 4 workers. Stop. Insofar as the district of Mon is concerned,
He have been approved for appointment, Your Lordship.
has been, you right, shortlisted for appointment. To be proceeded with after due verification. Stop. Insofar as the district of Mon is concerned, the respondent number 5 has been shortlisted. Stop. It is the submission of the counsel for the petitioner that he does not belong to this village.
Mm,
Why are you challenging his appointment? He submitted that the petitioner belongs to a landowner's family whose land was donated for establishment of the office in the district of Mon, government offices in the district of Mon. However, overlooking her claim, the private respondent has been shortlisted. Being agreed, the present petition has been filed. Then a government advocate appearing for the state submits that he would like to complete his instructions in the matter. Accordingly, let notice issue return in 4 weeks. The government advocate accepts notice on behalf of respondents 1, 2, 3, 4. As such notices are waived, extra copies be furnished within 1 week from today. Steps on respondent number 5 by usual course and registered post.
Your Lordship, I have my interim prayer, Your Lordship.
We'll consider after returnable dates. Prayer for interim. will
Yes,
be
Your Lordship.
considered on
And
the
this,
next returnable date after service of notice on respondent number 5. We'll make it subject to outcome of the writ petition that will serve your purpose. No,
Yes, Your Lordship.
mm,
no.
mhm.
We'll hear your interim prayer on the next returnable date.
Okay, Your
All right.
Lordship, yes.
Bless you.
Much obliged.
For motion, item number 41.
Yes.
May please, Lordship. Lordship, here I'm aggrieved for non-consideration of my application, Lordship. Lordship, what happened, Lordship? The petitioner mother expired while in harness, Lordship, in the year 2016. And then after that, she applied for any compensation appointment, Lordship. Now, Lordship, after my submission, it almost more than 8 years now. And Lordship, I'm relying on some circumstances that later to my application, who parents were expired in 2017, they were considered, Lordship. So that, Lordship, my application, Lordship, beg your pardon, Lordship, page 14 is the date of death certificate. If you, Lordship, you kindly turn to the page 14. This is the petitioner death certificate. So date of death is 25/8/2016. Now the second page, that is page 15, that is my application. Now coming as a Lordship to page 16. This is the declaration made by the respondent authority that none of my family members are employed in any government services and that. Now coming, Lordship, to the page 17. This is the appointment order issued by the state respondent, Lordship. Now this appointment order was issued whose application was made later to me, Lordship. And now the death certificate, Lordship. You, Lordship, may kindly turn to page 18, annexure 5, Lordship. So here it indicates this is date of death is 2/8/2017. So, and then, Lordship, I'd like to take to Lordship to my addendum. That is the page 23, annexure 8, Lordship. So I may be just allowed to read one paragraph, Lordship. That one, insertion of paragraph 11. Conventional appointment made to group C and D posts under this scheme shall be strictly in order of the date of death. And the first preference shall always be given against those who have died earlier and who fulfills all other eligible criteria. So Lordship, there is a clear discriminations and then
What orders were passed on your representation?
Lordship, till now, no order was passed. And then I'm waiting for more than 8 years. And then after making some queries, the petitioner could obtain some appointment order who a later applicant than me. So I feel it deemed necessary to
Why
approach
did you wait for such a long time
Lordship.
before coming to the court?
Lordship, I was expecting an appointment, Lordship.
Then how are you surviving?
Lordship,
You are the daughter.
Lordship daughter, and then no doubt the pension benefit was given. So by that, we are managing Lordship. So that's my simple grievance.
2016.
16.
Yes. Get your instructions in.
Your Lordship.
We can close it, but do you want a disposal today?
Lordship, my submission is that if the honorable court consider me to within a certain period of time for appointment, because as I have
No,
stated,
your appointment will be subject to the scrutiny made by the department.
Lordship, I agree with that.
Now, your grievance is that even your application which has been filed,
Lordship,
according to you, has not been disposed of or no order has been served on.
Lordship.
So,
And then Lordship, my grievance is that later to my applicant, those applicant were considered Lordship.
so
It is with
let them get their instructions here.
Lordship.
Right. Heard learned counsel for the petitioner. The petitioner is aggrieved by non-consideration of her application seeking compassionate appointment. As her mother, who was serving as a cook.
Lordship.
No, what was she working as?
Lordship. Yes,
She
Lordship.
was serving as a cook at Naga Hospital,
Lordship.
and who expired on 25/8/2016 while she was in her service. Stop. It is submitted that the petitioner's father also expired prior to the expiry of their mother. And as her mother was the sole bread earner for the family, her expiry during her service had left the petitioner and her 5 siblings in penury. So consequently, she applied for due consideration to be appointed in any suitable post under compassionate appointment. Stop. Learned counsel has referred to the death certificate enclosed to the petition to show that the petitioner's mother expired on 25/8/2016. Stop. The learned counsel has also referred to a declaration issued by the principal director, Directorate of Health and Family Welfare, Nagaland, to show that the petitioner and her siblings are reflected as family members of late Charlie Vienne, who is the late mother of the petitioner. Stop. It is submitted that in spite of the application made and the requests made by the petitioner, our case was not considered. However, subsequently, petitioner came to be aware that other similarly situated persons were considered and appointed. The petitioner is agreed that as per the office memorandum dated 17 September 2015, read with the addendum dated 9th of April 2019, The government of Nagaland has a policy for consideration of dependent family members or government servants who died in harness for appointment on compassionate basis, subject to their suitability. Stop. As per the subsequent addendum issued, the consideration shall be strictly made in the order of death, and first preference is to be given to those who died earlier and fulfills all eligibility criteria. So, Learned Counsel for the petitioner submits that submits referring to an order dated say 21st December 2017, issued by the government in favor of one D Solo, page number 17, who was considered for compassionate appointment to the post of sweeper under the Naga Hospital Authority. Stop. Learned Counsel for the petitioner submits that the authorities did not consider the case of the petitioner or pass any order rejecting her candidature, and overlooking that, and in violation of the OM dated so-and-so, read with the addendum dated so-and-so, the case of other similarly situated persons whose relatives on whom they were dependent expired subsequent to the death expiry of the petitioner's mother. So, being agreed, he has approached this court, filing for praying for appropriate writ direction or order. Mr. So-and-so appears for the government.
Government.
May I know your name?
M. Longkumar, Your Lordship.
M. Longkumar, government advocate.
Yes, Your Lordship.
Appears for the respondents and accepts notice on behalf of all respondents.
All the respondents.
All respondents, like such notices avail, extra copies be furnished within a period of 1 week from today. Let the matter be listed after the returnable date, by which date the respondents will apprise the court as to the status of the claim of the petitioner towards our compassionate appointment. Stop. Pendency of the petition shall not be a bar to consider the claim already made by the petitioner. Just after return of Lordship.
Invite Your Lordship.
For motion, item number 42.
Yes.
Maybe little Lordship. Lordship, here, the petitioner is also aggrieved by the non-consideration of the representation made before the competent authority. Lordship, the petitioner was under occupation of a land, of plot of land, on the strength of this allocation of site permit, Lordship. Then Lordship, what happened after enjoying for so many years, the petitioner could noticed some necessary correction to be made in the his site permit, Lordship. So Lordship, he has made a representation. That is page 14, Lordship. The first representation was made in on 15/4/2024, Lordship, for necessary, the matter is with simple, Lordship, for necessary correction in his this site permit after making some spot verification or necessary procedure, Lordship. So Lordship, because of non-consideration, again the petitioner has made a reminder request that is at page 15. So that was made on 28/2024, Lordship. So here also the petitioner has highlighted about the necessary correction to be made in his site permit, Lordship. So despite of all this exercise, the competent authority has not taken into consideration.
Where is the site permit?
Site permit is Lordship. The Lordship at page 12, an extra one. And then type copy will be at page 13. So this is the site permit, Lordship.
You want correction of what?
correction of area measurement because indication of the boundaries has been clearly given. But whereas when the measurement was assisted by the petitioner, there is a lesser measurement, Lordship. So accordingly, we have approached the petitioners approached the competent authority for necessary correction. That is the only my subject matter, Lordship.
This site permit gives you what? Temporary allotment
Lordship.
for running what? Shop?
For residential building, this and that. So we have on the strength of that site permit, we have constructed a permanent structure. And then we are enjoying the land under possession for more than 40, 50 years, Lordship. So my humble submission is earlier also this honorable court, which I have filed one similar matter. So since my prayer is really limited, so the matter may be disposed at this stage, motion stage. The relevant. You want to see? The relevant portion is at Lordship, page 3. If I may be allowed to read from this 3. Mr. Zemomi, learned government advocate, has no objection to the submission made by the learned counsel for the petitioner if the prayer is limited for disposing the representation dated 26 to 24, submitted by the petitioner that we Commissioner Mawuchong Nagale. So in view of the submission made by the learned counsel for the parties, this petition is resolved at the motion stage with a direction to the commissioner to dispose the representations and such submitted by petitioner by a speaking order within a period of 30 days from the date of receipt of a copy of this order, and any order passed by the commissioner shall be forthwith communicated to the petitioner. So in similar line,
Yes, Government, what do you say? Show him a copy of the order. You have a copy?
Yes, I have.
You have given him a copy?
Yes, Your Lordship, I have received it, Your Lordship. Now, Your Lordship, as far as the disposal of the representation is concerned, Your Lordship, that I have got no objection. However, Your Lordship, I have a small submission to make here. The site permit that the petitioner annexed in page 13 clearly indicates that the area is of 80 feet in length as well as in 80 feet in breadth. And the petitioner is contending and making an affirmation in the writ petition that this is wrongly indicated in the site permit that was issued to him in 2012. Lordship, there is no document showing that in 1978, 150 by 80 feet has been allotted to him. So even if the representation is being disposed of, Your Lordship, strictly in terms of the availability of the record in the Deputy Commissioner's office, if that can be.
Do you agree or you disagree with this order?
Your Lordship, since he has a very limited prayer made, Your Lordship.
Right. Heard, and it comes for the parties disposed. The end of para 4, you write, the petition is disposed of in the motion stage on the submissions made by the counsel to the petitioner and the deputy commissioner. What is this?
Lordship.
Bhandari, what is that? DC Dimapur.
No,
Deputy Commissioner Wokha, Lordship.
Deputy Commissioner Wokha is directed to examine the claims of the petitioner. And if the claims are found to be supported by the records available, in the revenue records available, then necessary orders will be passed within a period of 30 days from so and so. And needless to say, copy thereof shall be served on the counsel to the petitioner. The petition is disposed of with in view of the limited prayer for a direction to the ETC to dispose of the representation and without expressing any view on the merits of the case.
Lordship, deeply obliged, Lordship.
Deeply obliged, my Lord.
Yes, thank you. Maybe last slide.
For admission, item number 1.
There's an order.
May I please, Your Lordship?
Yes.
Lordship, I am appearing on for respondent number 6 in this matter. Your Lordship, recently the Honorable Supreme Court have passed a judgment incorporating certain law points. I was able to download it last night, and I would like to go through it, and a date may be fixed on the consensus of the parties on 2nd December, so that the matter
What is
can be
the
disposed
matter
of.
about?
My lord, I'm the counsel for the petitioner. We were challenging the recommendations of the selection committee for appointment of secretary, assistant governor's secretariat. The challenge, basically the challenge is that rule of the game cannot be changed after the game is over. So at the time of hearing, my senior counsel Takamasa, he pointed out that the judgment that I relied upon has been referred to larger bench for consideration, whether this principle will remain or not. Finally, on 7th of this month, including with the CJ, 5 judges has upheld the same principle which I have relied upon. So that's in short, and this has been placed after 8 years. Yes.
So you want to say that the judgment which you relied upon?
Yes,
has
that is
been-
upheld.
That has been upheld.
Upheld by the larger bench.
So
So my friend is asking time now.
If the matter can be fixed on 2nd December, so that I'll go through the judgments along with the facts of the case, because
you apprise us on Thursday. If it is to be covered, then what is to be done?
Yes.
no, Your Lordship, apart from this recent judgment, the same batch have certain batch of writ petitions were filed with this. So the matters were bifurcated and separate orders have been passed
Where?
in the same by the same bench in the same case. So those orders I would like to go through also and
Right.
download, so that I can apprise the court.
Request of learned counsel appearing for the respondent.
My name is not reflected in the cost list. If that may also be reflected.
Your name,
Respondent number 6, Arun Long Longkomar, Lordship.
Mr. R.N. Longkumar,
Yes.
appearing for respondent 6, submits that the recent judgment, the apex court has delivered a recent judgment which will have relevance insofar as the issues raised in the writ petition is concerned. And he would like to peruse the same judgment and apprise the court thereafter. So Mr. Azo, learned counsel to the petitioner on the other end, submits that the apex court has upheld the view which the learned counsel has relied on before.
My lord.
Therefore, the writ petition can be disposed of in terms of this judgment laid by the rendered by the apex court. Mr. Zimobi appears for the state government.
No, Lordship. K. Angami, Lordship.
Sorry, K. Angami appears for
Respondent number
State government.
1 to 5, Lordship.
1 to 5. Stop. Considering the prayers made by the counsel for respondent 6, matter stands referred to be listed again on
2nd of December.
2nd of December.
Majum.
Our name may be reflected in the cost list.
Registry to reflect the names of all councils in the course list, including names of respondent number 6.
Much obliged, Your Lordship.
Majum.
For admission, item number 2.
Your Lordship, this item the pleadings are completed, so if this matter may be listed for admission hearing for next week.
Why?
My lord, I've received the affidavit in reply filed by the petitioner just now. So the
Councils and the bar submit that the pleadings are complete. The matter be listed next week for admission.
my lord, in that case, my lord, buildings may be completed, rule may be issued, and then let it be listed for hearing in the usual course.
There is an interim order.
No. There's no interim order, my lord.
We issue rule.
Yes, my lord.
Yes,
It's submitted that pleadings are complete, issue rule. Matter be listed for hearing.
much obliged, Your Lordship.
For admission, item number 4.
Yes.
May I please, Your Lordship? This is a case of premature retirement. Before the actual date of retirement, I was made to retire with a retrospective day counting the length of service from the date of initial training. Petitioner is working as HA in the office of the original Gauhati High Court, prosecuting Gauhati High Court.
HA means
Head assistant.
head assistant, okay.
Now, little background watching, summary. As Lordship is very aware, in Nagaland, there is an act called Nagaland Retirement from Public Employment Act. And as per this act, a person shall retire from government employment, public employment, either on completion of 35 years of length of service or on attaining 60 years of age. So 2 ways. We are concerned with the length of service. For computing the length of service, the question is from which date it has to be computed. And in this connection, the state government has issued notifications from time to time by way of issuing office memorandums. And the latest office memorandum is of 2017, which says that the computation of 25 years of service shall be computed from the date when a person is appointed on continuous process. In other words, if there is break or gap in the service, that will not be computed. That is because of the fact that Lordship is really aware, as per the pension rules. When there is a break in service, definitely the pension will not be given. A person is not entitled to avail pension. And the basic fundamentals of pension rule is there has to be continuity in service. Then only a person becomes eligible to avail pension. That is the reason why apparently the office memorandum may have been issued by the government also, that there should be no break or gap in service. So what happened? The petitioner was appointed on contract basis initially on 2nd of August 1988. So going by this, he will retire in 2023. But his contract appointment was extended from time to time. And at one point of time, there was some break and there was no extension of his service. Therefore, in order to avoid all these complications, the department and the government has determined a date, that is the last extension order, that is 17th of November 1989. That was treated as the determining date for counting his length of service. In terms of this, all service benefits, everything has been computed. And even in the website of the department, before filing the writ petition, the due date of retirement of the petitioner was shown as 30 November 2024, 30th of this month. The website before filing the writ petition. By filing the counter affidavit by the state, they have made a categorical statement that after filing the writ petition, during the pendency of the writ petition, the entries in the website has been changed. After filing the writ petition, and they have made a categorical statement in their affidavit that this entry has been changed after consulting the records. Now, the earlier website, before filing the writ petition, which shows the date of joining as 17/11/1989, and the due date of retirement is shown as 30/11/2024. And that was the record maintained all along by the department. Meantime, this may not be relevant with the retirement, but this will be relevant so as to take an inference about the decision-making process of the department. There has been 2 or 3 cases in the meantime, because there was a situation when whether the employees posted in the Advocate General's office establishment at Gauhati shall be treated at par with the employees of the Civil Secretariat Service, or they should be treated as different category of service. That was the issue. And I have been treated among the prosecution section. Therefore, the petitioner filed a petition that, look, I should be treated as an employee of the Secretariat Service. So that was allowed. For not complying, the order contempt was filed. So during this period, lot of differences were there with the department. That means that must be the possible reason why. Immediately after the contempt petition was disposed, they have issued the order to retire me from service with a retrospective date, not as per the date which they have projected, and as per the date which is fixed on the basis of the opinion given by the PNER department. And the department has been using all this from 17/11/1989 because of the fact that there has been a lot of discrepancies. In order to avoid all this, let us take it to mind this 17/11/1989. So that should be the date, and when by that date, I'm due for retirement on 30th of November 2024, which is approaching very soon. But then they have made me retire from 36/2023. So I'm considering the basis. What is the basis of making me retire with the retrospective date before attending 35 years of length of service, starting from 17/11/1989. That is the short parameters of my case. Lordship, kindly come to the appointment order. May I draw your Lordship's attention to the appointment order at page 24. This is the initial appointment which was made on contract basis. It was made effective from 26/88. So this has been made as the determining date for computing my service, length of service to retire from service. The order is dated 2/8/1988 and it was made effective from 26/1988. So they have made me retire counting from this date and released from service with effect from 36/2023. So this is the initial appointment order, which was on contract basis. And
Yes.
Annexure B. That copy Lordship will find at page 26. This is 26 September 1989.
Yes.
This is where, in continuation to this department's order every number dated 1989. I could not find this order also. The appointment of Sri Surjit Singh as Herode cum Davis in the office of the Advocate General Nagaland, Gauhati High Court, Gauhati is hereby extended under the same terms and conditions till 31/10/89. So in view of this, in view of the gap and break of 16 days, and there were many anomalies. Therefore, the department as well as the PNER has taken the date, the determining date as 17/11/1989. Kindly come to next page, page 27, Annexure C. This is the order which was treated as the determining date for counting 35 years of length of service. This should have been taken. And the department has taken this as the date of training. In continuation to this department order, even number 26 September 89. That is in page 26. The appointment of Sri Surjit Singh as Herode cum Davis in the office of the Advocate General Nagaland, Gauhati High Court is hereby extended on the same terms and conditions till further orders. So
Yes.
this order has been treated as the initial appointment in view of break, in view of so many anomalies. Now, can we come to election T, page 29? This is the regularization order. This was made effective from 3/3/1993. The order dated 13th December 2002. This is the regularization in the post of LDA.
With effect from 3/3/93.
Yes,
So his effective date would be from 3/3/93.
yes, regularization.
No, regularization is with effect from 3/3/93.
Yes.
So his regular service would be counted only from,
No, lordship is like this. There are various notifications. Earlier, there were cases. Ad hoc contract services should not be counted for computing the length of service. Those were the issues involved in other cases. That is the reason why the state government came with a notification that, no, even if a person is work on a job contract or work charge, so long as the service, there is continuity in service, then that will be counted. That must be the possible reason why they have issued those notifications. And although he is regularized only from 3/3/1993, his initial training, which the government has taken, department has taken, that is 17/11/1989, has been taken, determined.
no, determined by which order? Is it by any specific order?
Later on, I will take your lordship to that. We'll go systematically, lordship.
Right.
Page 30, annexation E. One post of lower divisional assistant come type is under the establishment of Advocate General Nagal, Gauhati, created by order so, which was subsequently upgraded to the post of UDA by Department 7 number dated from so, is hereby redesignated as LBA in the case of, this is the redesignation order. And this order has been issued with the concurrence of the Interior Department. The petitioner was downgraded and redesignated in view of the regularization in the post of LDA. Although he was holding the post of UDA.
He was regularized in LDA.
Yes. So it was downgraded and redesignated as LDA because his regularization is in the post of LDA. And the regular vacancy was also available only in the rank of LDA. Now, page 31, annexure F.
Yes.
By this order, the post of LDA has been upgraded and given official promotion to the post of UDA.
Yes. Officiating promotion.
Yes. And then this promotion is made subject to regularization by the Department Promotion Committee. That's paragraph of right?
Yes.
And then thereafter, I have submitted a presentation. And then referring to fields. And then page 35 is the letter by the Advocate General that the petitioner should be placed at par with the employees of the district level of state is misplaced. So he has requested to treat him as an employee at par with the civil secretary, like other employees in the law department. Annexure I, page 38, that is 4th September 2015. This is an order by the law department, by who is the public information officer. When I have submitted the RT application, they have replied like this. With reference to your letter number 3rd August 2015 on the subject cited above, I am directed to inform you that no district promotion committee has been held for promotion for employees under road department since 1/1/1998. Further, this is important. Office of the Advocate General Nagaland falls under secretariat level. So this is the order from the law department.
Yes.
And Lordship will find in page 39, one order of this honorable court, which is ordered at 2/11/2018. This case was pertaining to regularization of official promotion in the post of UDA and claimed the pay scale at par with the civil secretariat employees. As Lordship has just seen in the previous order, the law department has said that you are in the category of civil secretariat employees. So this order is pertaining to that for regularization of official promotion in the post of UDA and claim the pay scale at par with the civil secretariat employees. For deciding this issue, the present issue, this will not be relevant, but there has been some litigations where the bill agitated for taking them to court on several occasions. And can you come to page 54 also? The petitioner has filed an appeal.
One minute.
The relevant portion is in page 55. This is the order in the RTA application.
Page number
Page 54.
54. Yes.
This is by the Secretary and First Appellate Authority of Law and Justice Department. This RTA application has been disposed of by this order. Can they come to the relevant portion at page 55, the next page? I'm referring to the last paragraph.
Yes.
The First Appellate Authority, in order to give ample opportunity to address the grievances of the appellant, fixed 33/2023, 24/2023, 17/5/2023, and 14/7/2023. However, in spite of presenting his grievances, he has undermined and insulted the authority of the First Appellate Authority with the word. The direction for physical appearance before appellate authority is uncalled for and divorce the rules of the RTA Act. That instead of cooperation to the authority, rather challenge the authority which attracts unbecoming of a government servant, attracting disciplinary proceedings under the Nagaland Government Servants Conduct Rules 1968. The intention, the motive of the appellant appears to be nothing but to harass and torture the authority by misusing the rights as comfort to all the citizens of the country under the RTA Act. Therefore, with the observation of the bill dated 15/2/2023 stands dismissed. Petitioner has sought for the virtual hearing and all these things, but they have taken it otherwise that you are challenging the authority and taking the authority and harassing all these things. So this is uncalled for. Page 56, election P. This is the minutes of the Departmental Promotion Committee meeting held on 25/9/2019. The Departmental Promotion Committee of the Justice and Law Department had a meeting on 25/9/2019 and recommended for regularization of the official promotion of Sri Sarjit Singh UDA, Office of the Advocate General, Gauhati High Court, Gauhati, with effect from the date of the official promotion to the post of UDA as per the clearance of PNPR Department, OM 15/4/2019.
So is effective from 7th of March.
But they have not made any mention about that.
With effect from the,
With effect from the date of official promotion
so
to
that
the
is,
post of UDA.
that is 7th of March. That is 7th of March. I think.
Official promotion was
7th of March.
Page 31.
Yes.
7 March. Again, page 58. 27 September 2019. In the interest of public service and under recommendation of the Departmental Promotion Committee held on 25/9/2019, the official promotion of Surjit Singh from LTA to UTA in the office of the Advocate General Gauhati High Court, Gauhati, is regularized from the date of Departmental Promotion Committee sitting. So from the date of sitting the committee, this was given.
Yes.
Thereafter, for not complying with the orders passed by this honorable court, the petitioner was compelled to file a contempt petition, page 69, page 60, sorry. And that contempt petition was disposed of by order dated 8/6/2023. And after disposal of this contempt petition, all adverse decision has been taken by the department against the petition.
Yes.
Now kindly come to page 64, annexure T. This is the tentative office memorandum dated 6 July 2023. Tentative seniority list of LDAs and UDAs under prosecution establishment was on 31/4/2023. Against this order, the petitioner has submitted a representation that I should not have been placed before the prosecution establishment. So this is contrary to their own order. Why I'm submitting that lordship, kindly come to page 38 again, once again. Page 38. Here, the last two lines lordship will find, page 38, annexure I. Further, the office of the Advocate General Nagaland falls under secretariat level. So here, the public information officer, when information was sought, this is the reply by the department. But here, again, I have been placed under prosecution establishment. So this is contrary to your own order, which lordship has found in the page 38. And then kindly see the next page, page 65.
Yes.
Page 65, kindly see. Even in the seniority list, this is by the department.
No, why this 65 that you're showing, from where do you say that this is contrary to the view in page number 31? Sorry, 38?
I'm referring to page 64.
64.
Yes. Here in the subject lordship will find tentative seniority list of LDAs and UDAs under prosecution establishment was on 31/4/2023. And if lordship sees the next page, that is page 65, my name is shown there, the petitioner's name. Seniority list of LDAs, UDAs under the Advocate General Establishment, Law and Justice Department was on 31/4/2023. And the name of the petitioner is shown. Here, there are two purposes here by relying on this page 65. By this order, I have been placed under prosecution establishment. That is contrary to what they have said in the page 38. That is, I should be treated as secretariat level service. Secretariat level service and the prosecution wing are different establishments. But I have been shown here under prosecution establishment. That is one. Another purpose of relying on page 65 is.
It does not say secretariat service, it says secretariat level.
Secretariat level. So pay should be in that level.
Okay.
Now, page 65. This is your own document. The reason for referring to this is.
Where is his where is his upgradation order to head assistant?
That the order is not in close structure.
Right. Okay, then,
Page 65.
yes.
This is issued by the law department. And Lordship, you can see the column. My name is shown. Second column, designation. Third, date of birth. Fourth, office. Fifth, date of entry into service. 17/11/1989. This is not my record. This is the record. Date of entry. And date of promotion to UTA to HA 1/7/2022. Second last procedural file. Date of retirement 30/11/2024.
Alright.
This is the record. So all along, this was maintained like that. And on 20th July 2023, I have submitted the representation. Last paragraph, page
No,
67.
What did you say? Yes, last para.
In view of the above, your honor is earnestly requested to treat the establishment of the office of the Advocate General Nagaland in the separate category that of this secretariat level office and not in the category of establishment of prosecution wing of the lower judiciary, which is a district level office and operation. Because Lordship, district level office and the secretariat level office, although all are LDA or all are UDA, the pay scales are different. So if I'm placed under the district category, then my pay scale will be lower. Even if I'm holding the same post, either UDA or LDA. But in the secretariat level, the pay scale is higher. That is how this representation has been submitted.
Right. Then,
So the Indian order, we are coming to the most important orders. 68. Second last page. That's the first credit.
yes.
This is 17 August 2023. Under the provisions of the Nagaland Retirement from Public Service Second Amendment Act 2009, Sri Surjit Singh, Head Assistant in the Office of the Advocate General Nagaland, Gauhati High Court, Gauhati, under the Department of Law and Justice, is hereby released from public service as well as from acquaintance row with effect from 30/6/2023 on completion of 35 years of service. This order was issued when I was working as a head assistant. It was issued on 17 August 2023 and it was made effective from 30/6/2023. This order was issued basing on the initial appointment of the petitioner, which was made on contract.
Yes.
And can we come to next page, page 69? This is from the PNR website. In view of various anomalies, as I was mentioning earlier, 17/11/1989 was taken as the date of joining the service. And in page 69, last one, the serial number 3.
Date of retirement is not reflected.
Date of
This particular document.
Yes, but date of joining has been reflected.
Right. Now, this particular document at 65, this table.
and the government website, it tallies.
Yes, except for the date of retirement.
Yes, date of retirement is not shown.
Yes. This
Entry of date of
six-
training,
65
Lordship,
information
yes.
is obtained from which document? It's from the government files.
First, page 64. It is a continuation of,
Okay,
this is the seniority list. Continuation of page 64.
all right,
This is enclosed by the department.
okay.
And this and the website of the department, date of training is 17/11/1989.
Okay.
After filing the writ petition, as I was mentioning earlier, the department has corrected this.
89.
Yes, writ petition was filed on 29/8/2023. And for a moment, kindly Lordship.
What, it was corrected to which date?
Government affidavit,
You are referring to 17/11/89.
yes,
Okay,
the government has corrected this and they have enclosed in their affidavit. Affidavit in opposition on behalf of respondent number 1, 2, 3, and 4.
affidavit in opposition.
Yes, of respondent number 1, 2,
Yes, page number.
page number 9. Last extreme right column on the top. Date of training. 26.
Page number 9.
Yes.
Oh, sorry, this is
Government
affidavit.
affidavit in opposition of respondent number 1, 2, 3, and 4.
Page number 9.
Government has filed another affidavit, the latest one, but
Yes. Where is this? Surjit Singh.
9, extreme right.
This will be number 10. Serial number 10. Page number 9, serial number 10, is it? In the
Lordship
table?
must be holding another affidavit. We have filed 2 affidavits. That is not the one, Lordship.
Oh,
That is the latest affidavit. I'll come to that also. That's right.
okay. All right, affidavit on behalf of 1, 2, 3, 4.
Yes.
Okay. Page number 9. Yes.
Mr. Lordship,
Yes.
extreme right. Date of training is 26, 20, and 1988. On the basis of this, I have been made to retire.
And what was the date in the writ petition? 89.
17/11/1989.
89.
Going by that, I am due for retirement on 30th November 2024. Lordship, the statement, the annexure which is filed in page 9, annexure 2. The statement they have given in paragraph 13. They have admitted that they have corrected it. And before switching on to other documents, the document which they have enclosed, they have stated in paragraph 13 of their affidavit,
Admitted in
paragraph 13. To say that correction has been done. That with regard to the statement made in paragraph 26 of the writ petition, the department respectfully submits that the competent authority has, based on the petitioner's service record, corrected on the website the date of training of service of the petitioner as 26/1988. This has been done after filing the writ petition, as I was submitting. The writ petition was filed on 29/8/2023. And after that, only this correction has been done. Otherwise, all along, it was in the record of the pioneer, in the website of the pioneer, that the date of training of the petitioner is 17/11/1989.
Yes.
And can we come to my affidavit in reply? Affidavit in reply against the affidavit in opposition filed on behalf of respondent number 1, 2, 3, and 4.
Affidavit in reply. Yes.
I will be allowed to read 3 paragraphs.
Yes.
Paragraph 4, 5, and 8. May I read paragraph 4?
Yes.
That with regard to the statements made in paragraph 11 of the 11, the answering deponent picks to state that the petitioner does not deny that his initial appointment was with effect from 26/1988 and throughout his service, entire service career, his service was extended as many as 5 times by order dated 28/1988, 39/1988, 23/1989. 26/9/1989 and 17/11/1989. This is the latest extension order. But the complication arose in his 4th extension order dated 26/9/1989, in which it was not specified as to from which effective date his extension is to be counted, although the date of expiry of his extension period was mentioned. This is very important question.
No, he joined initially on, let us say, temporary or ad hoc service.
Yes.
Then he was regularized in LDA
Yes.
with effect from
93. 93.
93. So your effective service has to be counted from 93.
No.
No.
Yeah, it is as per the, I'm admitting that as per the act and the notification issued from time to time.
The
So
government,
long
your,
as the government servant, there is continuous service, even if at all, work charge. If there is continuous service and he has stored his salary for an entire period will be counted for the purpose of retirement.
all right.
There is no issue on that. I'm admitting that fact. But why I'm referring this is, in view of so many extension orders, and in the second last extension order, no date is mentioned, extension order is up to which date? That is not mentioned. So the last extension order was 17/11/1989. From there is no differences, no gap, nothing, continuous service is there. Therefore, this date was chosen by the department as well as which was accepted by the PNR department in because the matter was referred law department, normally other departments refer to the law department. Now, law department, the only option they have to do is to refer to the PNR department, which they have done. PNR department has also said the case. In view of so many anomalies, the 17/11/1989 should be taken as date of training. That is how this was treated. All service benefit, everything in terms of this order. That is why I'm referring to this, and when we come to the chart also.
You can have your water break if you want.
Nice.
Hey,
When we come to page 4.
why don't you place some glasses here? Glasses. Both sides. That's the court master.
For us, not in picture view.
Yes.
page 4, there is a chart. I'm referring to column serial number 4.
Yes.
This is the different orders by which my service has been extended. Order number so and so, this is up 89, extended till 31/10/89 without giving the effective date. And on the extreme right column, order passed on 26/9/1988, saying that this is in continuation of the order passed on 1/9/1989. Whereas there is no order dated 1/9/1989 in existence. They are referring to this letter order, but this order is non-existent. They are basing their claim on a non-existent order. Regarding this order, there is no mentioning in the service book or in the note sheet of the personal file of the petitioner. This order is passed on 17/11/1989, and the previous date from where it is extended is not mentioned. Whereas in all other orders, the previous date is mentioned. And paragraph 5. That with regard to the statements made in paragraph 12 of the answering, the opponent denies and brings to state that the petitioner ought to have been given prior notice as is required under the Government Notification number 14/6/2013, and without giving such notice and issuing the emblem order dated 17/11/2023, retiring the petitioner from retrospective date is not permissible and at the same time, the respondent authorities have acted inconsistent with their own record. And also kindly see page 8.
What
paragraph 8.
what is the maximum service you said? 35.
35 years of length of service, that should be continuous.
35 years.
Yes. And then the 60 years is by age. Paragraph 8 at page 6. I will read this paragraph only. That with regard to the statements made in paragraph 16, the answering opponent denies and reiterates the statement made in paragraph 4 of this affidavit in reply, and humbly begs to state that the petitioner was appointed on contract basis as LDA Count Davis with effect from 26/1988 in the office of the Advocate General Nagaland on contract basis for a period of 4 months. The dates are shown. Thereafter, the appointment was further extended for 5 months till 19/3/1989 by order dated 30/9/1988. The service of the petitioner was further extended by the order dated 22/3/1989 and was specifically extended from 23/1989 till 31/8/1989. In all the orders of extension, the effective date and the extended date is clearly mentioned. But where the order dated 26/9/1989, a further extension was given till 31/10/1989, mentioning that this is in continuation of order dated 1/9/1989. The respondent authority has failed to produce the order dated 1/9/1989, in continuation of which the order dated 26/9/1989 was passed, meaning thereby that there was a gap of 25 days from 1/9/1989 till 25/9/1989. Further, the answering deponent wishes to state that the OM dated 4/5/2017 was issued for counting the past service for the purpose of pension in a situation where the service of an employee in the past service can be calculated precisely, but the case of the present petitioner is in a peculiar situation where the effective date for counting his extension period in his fourth extension order dated 26/9/1989 cannot be ascertained, and as such, the date of joining as claimed by the respondent authorities by applying the aforesaid office memorandum is totally misconceived. Because the office memorandum which is enclosed in the government affidavit, it is very clear that how to determine?
No. You don't dispute that your original service was in 88.
Yes,
There's no dispute.
yes,
You also don't dispute that the rules say 35 years of continuous service.
yes.
So if there is 35 years from 88, your retirement will be in 23.
That is why,
Hmm.
to clarify this, OM has been issued by the government, kindly come to government affidavit, that is affidavit in opposition of respondent number 1, 2, 3, and 4.
Filed on 22nd July.
5th May 2023.
The respondent affidavit of respondent.
1, 2, 3, and 4. I have received one 5/10/2023. I do not know when we have.
There is one affidavit.
We have filed two affidavits, one in present report order, that is, we have filed on 11. But I think the petitioner now hearing is referring to the.
Yes, affidavit, the first.
First step.
affidavit, yes, Your Lordship.
Mr. Lordship, better.
Yes,
Then can we come to page 22?
22.
Yes.
Yes. Office memorandum.
This is office memorandum dated 4th May 2017, and this is the latest office memorandum concerning the accounting of length of service and for determination of government employees for the purpose of retirement option. Relevant portion, paragraph 6. I believe Lordship's query will be answered by this. Page 23.
Yes. There are 6.
Yes, very important.
Yes.
Now, therefore, it has been decided that the period of service rendered on a top contract or charge substitute basis, which is followed by regularization or regular appointment without break or any gap in service. That is very important. Regular appointment without break or any gap in service, except resignation, shall be treated as public employment and included in computation of length of service for the purpose of pension under the Nagaland Retirement from Public Employment Second Amendment Act 2009. So, to compute the service of length of 25 years, there should be no break or gap. Because earlier, there were cases, those are mentioned in the office memorandum itself, that substitute basis service should not be counted because they are not regular service. But then if the employee have received salary, then that will be counted. That is the principle, and there should be continuity without any break, so as to compute 25 years of length of service. Admittedly, I joined in 1988, but the government.
What is the length of service for pension? 20.
Up to 20 years, one becomes entitled for pension.
This is for the purposes of pension.
Yes.
This is for counting the services for pension.
My retirement is not on the basis of my date of joining, as has been mentioned by the department, that is 1989. But they have taken the date of joining from the initial date of joining, but in between there was break. When there is break, it cannot be counted. Paragraph 6 is very clear. Without any break gap. So in paragraph 4 to my affidavit in reply, I have clearly mentioned.
No, you're referring to para 6 of the OM.
Yes.
So the para 6 of the OM is to count the period of service on ad hoc, contract, work charge, substitute basis, whatever, followed by regularization without any break or gap,
Yes,
except I don't know what the registration. That's
except resignation. This
Uh,
is not registration, but this is resignation.
shall be treated as public employment for the purposes of pension.
Yes. That should be
So-
without break or gap.
Right, so that is only for the purposes of pension, not for determining your date of
No, no,
retirement.
They have mentioned as pension. The Retirement Act is,
No, you are saying that there is no break from 89.
yes,
That's your case.
yes,
Government says no, it is from 88,
yes,
right? Now, on one hand, if you say 89, then you tend to retire in November 24th,
Yes.
2024.
yes,
And if it is 89, then you have already retired, which is the government stand. But if you say it is 89, then you lose 1 year of calculation towards pension.
it is not only for the purpose of pension. I should retire on the due date of retirement.
No,
That
but,
is 30th
but
November.
this clause 6 doesn't appear to
No,
be.
without break or gap.
No, but it doesn't appear, it does not perhaps indicate that this is meant for determining the retirement age. Your retirement age will be determined on the date it is entered in the service book, which according to me, I don't know, according to me should have been in 93, because that is the date you were regularized in the service. Now, if the government has taken that extra service, it is for the purposes of pension is a different issue. Regularization of service in LDA with effect from 3/3/93.
Yes.
So on a date you enter into the service, 88 or 89, there will be an age reflected in your service book will be open from 13 December 2002.
Service book will open from the date of initial appointment.
In Nagaland.
Yes.
Even if you're ad hoc.
Yes.
Okay.
Entries will be there.
Huh?
Entries will be there. A top service, extended service from so and so period, all these things.
So what is
So
what is
there was a breakup.
what is the date of date reflected in your service book?
It is 17/11/89.
89.
Yes. On the basis of this 89, all service benefit, everything has been granted, and your own website has been maintaining that. And in the seniority list, which has been shown by the department, it is 17/11/1989. Then suddenly why another date?
No, right.
And that too, it was issued with a retrospective date. The retirement order was issued in the month of August. And I was made to retire from June, 30th of June. So on the day of issuing the order, I was still working. And it was made from a retrospective date. My lord, there is an order was released number 4. Where
Yes.
I'm hearing the issue to some
Let
extent.
let us just go through the OM once again from NHS 6. You may read the OM from clause 1. Yes, please.
What, Lordship's query. What the Lordship is putting me a query. That was my submission in the earlier cases. Actually, the length of service should be computed from the date when a person is appointed on regular basis. There are decisions of the ethics code that the contract service cannot be treated as a government service. All these things are there. But by ignoring all this, government has been strongly taking a decision that even if it is an ad hoc or charge substitute, so long as the received a salary, then that should be treated as public employment. But the definition of public employment of the pensionable service. Public employment says that appointment to any post or service under the government plan, which counts for pension. The definition was very clear. So, in order to count a service under the Retirement from Public Employment Act, it has to count for pension. And when it has to be count for pension, there should be no break or gap. So, their latest office memorandum, it is okay. In the sense that without break or gap, it will be counted. But then, even if there are break, they are counted. Which is against the Nagaland Retirement from Public Employment. Because which counts for pension. So the service has to be counted for pension. And in order to grant pension.
They're counting your pension from 88. And you're counting the pension from 88.
Yes.
So according to the government, there is a pensionable service. You are saying that is not a pensionable service.
Difference will come when it goes to AG for claiming my pension. Accountant General will stick to the pension rules. Say, no. There was break in service, so we cannot grant a pension. Again, I have to come back. Because I was submitting initially, the fundamental principles of granting pension is, the pension rule is, there should be continuity in service. And if there is break or gap, no pension. That is why the very public definition of public employment, appointment to any pensionable public service or post, which counts for pension. Therefore, the service should be counted for pension. That is why I was submitting that whatever Lordship query is coming from Lordship side is perfectly okay, and that was my submission initially. But this Honorable Court did not accept that. Saying that any appointment, whether I took contract, it should be counted. That's how, basing on those judgments, the office memorandum has been issued. Rightly or wrongly, the office memorandum is there, law is there, we have to comply with the law.
No, this office memorandum. Yes, it talks about continuous service, but it's towards the length of service towards pension, whether that period will be counted or not.
Lordship, on 6/6/2024, this Honorable Court passed an order.
In this matter.
Hearing to some extent, yes. And government was directed to file an affidavit. And the affidavit which Lordship has initially picked up, that is the affidavit again.
Okay.
This affidavit is in terms of the order to the 6/6/2024. First, we are referred to the judgment. It is a two-page judgment of order only. And thereafter, I will come to the statement.
Yes.
Made by the government. Page 5 is the order.
So on you're reading from the affidavit?
Yes.
Okay.
Government affidavit. With some emotion like this chart.
Yes.
Correct?
Yes.
Page 5.
Yes.
Read it from second paragraph.
Yes.
The issue involved in the instance proceeding is as to whether petitioner's 25 years of continuous service should be counted with effect from 26/1988 or from 17/11/1989. Inasmuch as it is the specific case of the petitioner that while voted at 26/9/1989, the service of the petitioner was only extended till 31/10/1989. Thereabout, there was a gap in service and it was only on 17/11/1989. The service of the petitioner was extended until further orders. 3. On the basis thereof, it is the case of the petitioner that the petitioner ought to have been returned on 30/11/2024 and not on 30/6/2023, and as such, challenge the premature retirement of the petitioner, which has been done by the respondent authorities. It is relevant to take note of that on 2/4/2024, this court had directed the state authorities to keep the personal service record of the petitioner to be required as to whether there was any break in service of the petitioner prior to 17/11/89, or the petitioner continued to serve the state with effect from the initial date of appointment on 26/1988. In pursuance to that, Ms. S. Mary, the learned senior government advocate, has placed an instruction dated 8/5/2024, along with the salary roll of the month of September 1989. It is the categorical case of the respondent that the petitioner hearing had received the salary of the entire month of September 1989. Be that as it may, the question, however, arises as to whether the petitioner received the salary for the month of November 1989, which has not been placed on record, inasmuch as if the petitioner had received a salary for the month of November 1989, a different aspect of the matter would arise. Taking into account the above, this court fixes this matter again on 4/7/2024. On or before 2/7/2024, the respondent authorities shall file an affidavit bringing on record the salary roll in respect of the petitioner for the month of September 1989, October 1989, as well as November 1989. And the next day, the parties herein are directed to place this court the original service code of the petitioner. And then in the election, Lordship will file page 7. This is handwriting. On the top, Lordship will file for the month of September 1989. This is the payroll. And the serial number is at serial number 11 in respect of certain city. And on the extreme right, Lordship will find the amount and the by draft. The salary was disbursed by draft. Extreme right column. If Lordship has identified that.
Extreme right, I find the figure.
That is salary amount.
Salary.
The signature, all this, whoever received the salary will sign.
Right.
If it is by draft, then it is mentioned in the column
Draft.
by
Okay.
draft.
Okay.
And the next page is for the month of October 1989. Serial number 11, search C. And then on the extreme right column, Lordship will find by draft.
Yes.
So salary was dispatched by draft because it is between Kohima and Gauhati. And next is for the month of November 1989. This is relevant, very important.
There's no dispute on these months, is there?
No, Lordship,
This
here,
dispute is whether from 88 was there a break?
yes,
89, there's no dispute. You agree that you were there in 89?
no, but 59, it was in November. 17 November 1989. From there only, continuous salary was paid. Now here,
You have received from September also?
if it is for the month of November, then it will be
December.
December. If it is October, then see November, it is blank. And on the extreme right column, serial number 11, there is one IC who was a driver.
Hmm.
So respondents, although it is blank in my case, there is no signature, nothing about how it was dispatched. So there was no salary in the month of November. Now, by filing the affidavit in opposition, government has stated that he has received. So in paragraph 4 of the affidavit, how they have made the statement. Paragraph 4, page 2.
Yes.
Where the deponent picks to state that the payroll in respect of the petition Sri Sarjit Singh for a month of September 1989, October 1989, as well as November 1989.
You're reading from which paragraph, which affidavit?
Paragraph 4,
Same affidavit.
same affidavit.
Para 4. Para 4 begins with it is relevant to note. Oh, sorry.
They have stated,
Okay.
they have given the statement in paragraph 4
Yes, yes,
about the annexures.
yes.
That the deponent picks to state that the payroll in respect of the petitioner, that is Sarjit Singh, for the month of September 1989, October 1989, as well as November 1989, clearly indicates that he has been paid full salary for the period in question. Hence, there was continuity in service and there is no question of service break of 25 days with effect from 1/9/1989 till 25/9/1989. And then they have made the statement that the original service work will be finished. Now, I have replied that in paragraph 4. Objection to the additional affidavit, 10th affidavit also replied. In the both letters, it is mentioned as objection to the additional affidavit.
Yes,
Mr. Lordship, correct?
yes.
Paragraph 4. Here's statement in paragraph 4 is applied in my affidavit in paragraph 4. That the statements made in paragraph 4 denies and picks to state that there is no signature of the petitioner having received a salary for the month of November 1989, and that the signature shown as IC on 30/11/1989 produced by the state respondent is that of one Shri I. Singh, driver, whose name is at serial number 11 of the bureau. Incidentally, there were two Singhs. One is I. Singh, I'm Sarjit Singh. Incidentally, number 10, number 11. So, Lordship, you can clearly see signature is in respect of serial number 11, that is IC.
But this doubt, don't you think it would be cleared by calling for the salary statement of from 88 when you were held to be in regular service? Continuous service.
That can be ascertained. But so far as the month of November is concerned, that is the actual disputed area. Whereas in respect of all others, I was serving, so I was paid.
No, because you don't dispute that you were in service from 88.
Yes.
According to the government, it is in continuous service. Which means.
That is the only gray area to be decided by this number court. That is why
So
the direction was given.
for deciding that, we'll have to call for the 88 pay slips, pay records.
88 to it will be there.
Ah,
My gap is only few days.
oh,
That is in respect of 1 month, not fully 1 month. So that is 17/11/1989. From that day it was counted.
how are the salaries dispatched? By draft? No, but there are something
If
which,
it is encased in my signature should be there.
you mean to say that he has to come all the way from Gauhati to get his salary?
Doesn't come monthly, but once or twice. That's what I've been on your lordship.
So you check up the subsequent months.
Your lordship, the only allegation here, your lordship, is that there is a break. Now, on what basis the petitioner said that there is a break? There is no order notification to show that there is a break. We have already paid the salary and there it's.
No,
clear from there.
he disputes your extracts to say that he has not received salary for this particular month, November.
Yes.
That reply this morning only after received your lordship, please.
That is procedural instruction of
Then if you suppose, if you may say that, okay, November salary he did not receive, but he received it with December. 2 months salary he can receive or 3 months salary he can receive, but then it will be recorded there in your, there'll be some record. But learned senior counsel points out that earlier,
December is also enclosed, lordship.
earlier
In December, we have enclosed your lordship. Yes, yes.
from September, October, sorry, this is September, then October, then November and December. So what is there in December? No, that is IC, SC
For December this year.
is received.
And those days, lordship has correctly pointed out. When I cannot come personally, then I will entrust somebody and they will receive. So their signatures are there.
So it is possible that somebody may have received and the
No.
signature was not there in the earlier month, November.
If it is received by somebody, their signature should be there like the December. It is plain.
Even in the service book, your lordship, he used to come and say at one moment, it's not. That is what I was going for.
But
And the
salary
service-
statement is
service
made,
book is here, your lordship.
see the amount which is entered in the payroll. Amount is shown.
It is possible that somebody may have received it on his behalf.
We cannot go by assumption when the report speaks otherwise. If somebody has received, definitely your signature will be there.
Now, if he is not received for November and because there was a break in service and he has to receive for December, then there has to be an order.
Amount is shown.
Yes, there has to be an
December is
order or
shown.
notification. There is
Amount is shown.
No,
Let the petitioner show. the
no,
lordship.
no. You say that there was a break in service,
Yes.
which means you are continuing an ad hoc. And it was not extended, so you're not paid your salary. That is
Yes.
what you want to say. So in order to receive salary for December, there has to be an extension by the government.
Yes.
Let me see.
Where?
Government order is 17 November 1989.
Where is that order?
Page 28
The writ petition.
is. This is the type copy. And 27, page 27, original of annexure C. It is legible also. Otherwise, that copy is in page 28, but 27 is also legible. From this date, 17 November 1989, till further order. Last slide. From this date,
So you'd be entitled to salary from 17th.
yes,
Where is that salary?
you have not made
You have not
in
challenged.
December.
How can you give up your salary for more than 15 days? You'll not give
If
up.
I have received, then it will be reflected in the payroll.
No, assuming you have not received, but you have not claimed for that. If you are rightly entitled for that. Yes, all right.
In view of so many anomalies, this date was taken as the date of training. And this has been maintained by the department all along.
You are not, that is what I'm trying to understand. If 17 November is the date, 17 November 89 is the date of continuous service,
Yes.
initiation of continuous service, then your retirement is in 24.
Yes.
But the government says it is 88. Which month? In 88?
June.
June 88. So if it is June 88, you retire in 23, June. But you in your affidavit has not disputed that date. You say that, yes, I have joined in that service. Now to say whether from 28 till 17 November, there is continuous service or not, we'll have to see the records available to see whether you have received money for all except for these 10, 15, 20 days or whatever is there.
That is why, Lordship, I have referred to my affidavit in reply. In all the extension orders, from which date to which date, the date is mentioned.
Correct.
But for this particular case of 16 days, no date is mentioned. So my extension came to an end. Thereafter, fresh extension, latest extension order was issued on 17th of November.
I object to that.
No, no,
All
no.
the
Okay, let him complete, let him complete. You'll get your turn. Yes.
That is the justification, Lordship, I have given in my affidavit in opposition. And the reply.
Prior to 17 November, what was the date for your service extension?
That is in my reply. At page 4. Paragraph 4.
Have you enclosed an order?
Government is relying on an order which is non-existent.
What I want to know is this,
Government extension orders, yes, I have enclosed.
this 17 November. From 17 November, there is no dispute, isn't it?
Yes.
You are in service. Now you want to say prior to 17 November, there was an extension order.
Yes.
Which came to end maybe 10, 15 days, sometime in November or maybe end of October.
110.
That is it, page number 26.
Yes.
Okay.
Was up to 31/10/1989. After this order, the next extension order is at page 27.
17 November.
Yes, 17 November. Till for orders from this date continues. So my service ended on 21/10/1989. And after a few days break.
Until 17 November. And then it again started from 17 November.
Yes, not this break. So in view of this break, the government has taken this 17 November 89 as the date of training.
But if that is to be accepted, then you have to explain. There was a service break in September also.
Can you come to page 64 and 65?
64, 65.
Yes.
Yes.
64, this is tentative seniority list
Uh.
of LDS and UDS by the law department. And in the page 65, Lordship will find. This was in 6 July 2023. Then my name is shown in cell number 1.
No, we are not on that.
3 is 17.
We are not on that. You come to page number 27.
Yes.
27 is an extension of service.
Yes.
Until further orders.
Yes.
Issued on 17 November.
Yes.
You want to say that from 1st to 16th.
Yes.
There was no
Service.
order, there was no service.
There is no order.
Because this order came out in 17 November.
Yes.
It does not say it is with effect from 1st of November or any other prior dates. Now, same is the situation in page number 26.
Yes.
26 also says it is extended till 31/10/1989.
It's
But this order was issued on 26th of September,
September.
which means that at least from 1st to 25th of September, you are not supposed to be on service. If that analogy is to be drawn. But then you have received salary for September.
Lordship, because of all these anomalies, they have taken 17 November 89 as the date of training. There were so many anomalies.
No, see, these anomalies are in your favor because you are getting a larger pension after retirement. Because it has come from a retrospective date. Your pension will increase. It will be increased by 1 year, almost. You are trying to give away that.
If I start getting pension from 89 November, 17 November 89, then I'll be even serving working now and I'll enjoy a higher pension.
No.
By counting that.
You're getting pension from 88 to 23.
Date of service will be same, but they are going ahead, but it should be as per the law. Therefore, my date of training as per the report should be determined from 17 November 1989. And in which case, I'm due for retirement 30th of this month.
All right. You are relying on any authorities? Okay. Where is that?
When facts are very clear, it may not be relevant and necessary to rely on the authorities.
Where is the set of rules? Or you say that Nagaland
Nagaland Retirement from Public Employment Act.
Act. Okay.
That I can furnish about it.
It must be having a set of rules also.
It's in the Nagaland code also.
Your junior colleague can find out and inform the court master. Yes, government.
The only allegation that the petitioner has made, I mean, there are lots of amounts in regarding the break of service. We are saying that there is continuity of service, there is no break of service. What if there is break of service, then your lordship may put this to the petitioner, whether there is any order or notification showing that there is a break of service or termination, or in for that reason, your lordship resignation, your lordship. So that will, your lordship, that is the man.
That you will have to show us.
Your lordship here, yes, your lordship, we are saying, we have already filed our affidavit saying that there is continuity of service, salary has been paid for the month in question, your lordship.
Can you produce those salary receipts?
In pursuant to court's order, we have already they have already furnished the service to you. So if your lordship would like to peruse your lordship.
Have a look. Take out the service. There are orders which reflect that it was extended from time to time.
And also, it's in continuation of the earlier order.
But it does not indicate whether there was actually a break in service.
There can be no order to that effect, Lordship.
No.
Under which provision government should say that
No,
when
no,
there is a break, during this break, there was break. That cannot be.
no, no, no,
Cannot expect.
no, no, no. What we want to say from this service book, there is nothing to indicate that there was a break in service. The only thing is that it was extended. But if we get a hold of whether he has received his pay for all these months, then we can find out whether there was a break in service. Otherwise, it's a case of no work, no pay. If he has not worked for 15 days or 20 days, government is not going to release his money. That amounts to a break in service. Can you produce his documents? Just get the records, we can see it if it is available. Like there is a direction by the court to produce that September to December. That
Affidavit has already been filed.
I know.
This year they have been closed.
I know, I want to see the period from 88. That will reveal whether there is a break in service or not.
That would be irrelevant because I'm also admitting the fact that earlier there was extension from time to time. I was working, but relevant period is
only that
from
15
1st
days.
November to 16th November. There was break. Only that period. No need to go to others. It is an admitted fact that yes, I have been receiving. But since there is a break,
You don't deny.
I don't deny. I don't deny.
Okay, all right. All right, then anything more to submit? Heard, Senior Counsel, assisted by Mr.
I am Jim.
I am Jamil. And MS
As many.
S. Mary, then it's Senior Government,
Yes, Your Lordship.
reserved.
My reply, paragraph 4 of the affidavit in reply will make it very clear about the dispute.
I thought I will complete some pending work here, and I am taking it back. This we are returning it back.
Yes, Your Lordship. That will be, because
I'm-
in another repetition, they have a seek for financial upgradation and there is already a direction. So.
By the
this-
same petitioner.
Yes, by the same petition. So the service would be required for processing.
You give us that act you can give, they can find out.
Yes.
And we can.
And the notification is already a part of the report in the affidavit in opposition of the state.
Right.
That's one number 1, 2, and 3.
Right. Okay. Okay, yeah, keep it there.
For admission, item number 5.
For the last occasion, I've been time to seek further instruction, the Lordship here, it's the same. It's still pending, at the Law and Justice Department for waiting, Your Lordship.
Your affidavit.
No, Your Lordship, the case of the petitioner for consideration,
As for
they are praying for minimum,
pay scale.
yes. On the last occasion, I've submitted an instruction which I received from the, Young Secretary, Your Lordship. Dated 29/10/2024, Your Lordship.
It's not here.
All Your Lordship. Just fine.
This is October. You're referring to some Supreme Court judgment.
Your Lordship, in a similar case, Your Lordship.
Oh, that
yes,
was-
yes.
that was dismissed.
Yes, Your Lordship. So,
So the committee is still looking after it, examining the matter.
examining the matter, yes, Your Lordship.
All right. The heard learned counsels for the parties. learned government advocate submits that as reflected in the order dated 3/5/2023, passed by the Apex Court in SLA Special Leave to Appeal numbers 2242/2024 within bracket diary number 35341/2023. The government I don't know if this was the order. There was an order reflecting that the government is setting up a committee or something. This is the one.
I didn't place that committee. Set up a
Then
committee.
strike out
Just-
that.
Just the instruction which I.
There was a Supreme Court order where I remember seeing it. The matter is being examined by a special committee. Is it a special committee?
We look into the
By a committee set up to look into the issue of grant of minimum scale of pay to work charge / contract workers employed under various state government. So it is submitted that the matter is still being examined and she prays for further 4 weeks' time. Prayer is not objected to by the council for the petition, at least again after 4 weeks.
For admission item number 7.
Please, your motion. Matter pertains to pension. Whereas I have received instructions, however, I need further instructions.
Oh.
Yeah, great. 3 weeks time will be correct.
Lordship, here in this matter, in another case, same analogous connected, the matter will be listed on 6th December. 6th December, that is division bench. So that outcome will cover this case.
Oh.
So let the matter be listed on 7th of December.
Why 7th?
After.
Few days after that.
Yes.
If it is listed on 6th, then
Yes.
After the disposal.
right, it is submitted that, or we say to be listed after disposal of the writ appeal. It is submitted at the bar that the issue involved in the writ petition, present writ petition, which relates to grant of family pension,
Pensionary benefit.
pensionary benefits to the petitioner whose husband was an employee under the office of, in the court of Principal District Judge Dimapur, has already been decided by a coordinate bench, and the said judgment is presently pending before appellate court. Stop. Learned counsel appearing for the petitioner submits that this appeal is listed on 6th of December.
Yes.
So counsels at the bar are agreed that the matter should be listed after disposal of writ appeal number
It's contempt petition, Lordship.
contempt,
Yes, Lordship,
not writ appeal.
not written bill. But the Honorable CJ was taking on previously.
It's a contempt for non-compliance of
Of
a single
the-
judge order. Or a writ.
Single judge order.
Then you say covered by so and so.
COP, CBO 13/2021.
Covered by, it was already disposed of by a coordinate bench of this court and for non-compliance, a contempt matter has been filed. The COP number
COP number 13,
13,
2021.
2021. Stop this matter. It is informed that this matter is fixed on 6th of December, 2024. Councils at the bar submit that the writ petition be listed after 4 weeks. By which date the councils will apprise the court about the outcome of the contempt petition regarding the compliance of the directions contained in the connected writ petition, from which the contempt petition arose. Stop. Then Zimomi for the petitioner, Mr. Santang, additional AD for state, Mr. Muzoi for accountant general.
Yes, sir.
Accountant general. List again on the date after 4 weeks.
Lordship, after the disposal, because that will be again, there will be holidays.
Or we'll say after
Disposal, immediate of disposal of the contempt petition. After 6. Otherwise.
The submission was made by the AG. The state government is looking into the matter.
All right.
But
All right, after disposal of the contempt petition.
Lordship,
For on number 4 and 5 on behalf of Mr. Ajwan.
Oh, I'm so sorry. I thought you were assisting, Ms. Petitioner. Yes, MS Lucy note for respondents number
4 and 5 on behalf of Ajwan, the standing council.
for A is Zimomi, respondents
4 and 5.
4 and 5. I'm sorry, I thought you were assisting.
Right.
Yes.
Oh, Lordship.
For admission, item number 11.
Yes.
The Lordship, this matter is pertaining to the special incentive that was to be granted to all the doctors, including the health workers who served during the COVID-19 for at least 100 days. My Lord,
yes,
when the advertisement was issued, in fact, it was not even an advertisement, it was a letter. When it was issued by the department, the candidates were selected in a pick and choose manner, where the petitioners who have also served during the emergency time of the COVID-19, when it was at its peak, we have also served, but our names have been left out. So we also want to be included in that list, Your Lordship.
Lordship, sorry for interruption, but Lordship here in this case.
You're interrupting him.
No, Lordship. Lordship, in this case, petitioner is claiming the benefit of the cabinet decision. And in another recent case, the petitioner are challenging the cabinet decision.
Same petitioner.
Different petition. So, Your Lordship, I pray that this matter may be clubbed together with WBC number 239 of 2024, Lordship, and to be listed after 3 weeks, Lordship. Because in that one, notice is yet to be returned, Lordship. Because it's
Where is the, let us see the notification. The benefit which you want.
Your Lordship, may I take Your Lordship to the prayer itself? The prayer in the petition, Your Lordship.
Prayer.
Well, page 17.
Yes.
So, my Lord, prayer is to direct the respondent number 1 for modification, amendment, alteration of the cabinet decision dated 6 August 2024 in respect to the COVID-19 appointees to accommodate the petitioners to participate in the special recruitment drive. And B, my Lord, to watch and set aside the letter number so and so dated Kohima the 20th of August 2024 issued by the Principal Director, Directorate of Health and Family Welfare, denying the opportunity to the petitioners from participating in the special recruitment drive. And my Lord, the other petition that my learned friend is talking about is they do not want any special privilege to be given, and the entire exercise has to go. That is their standpoint in the petition which my.
No, you are claiming special privileges under which notification or order?
Your Lordship. No, Your
Cabinet
Lordship, it started a long time back, my lord, starting from 2021. So the notification dated 27/5/2022, which is at page 20 to 23, Your Lordship. The annexures 1, 2, and 3.
Okay.
Oh, my lord, my apologies, Your Lordship. Page 35, my lord. 35 to 42.
These were for contract workers.
Yes, Your Lordship, they were all appointed during the emergency COVID period. And to encourage the health workers, these incentives were introduced.
Where are the incentives?
Your Lordship, may I take your Lordship to paragraph 3,
Three.
page 35 of the petition, annexure 7.
Yes.
3, further with a view to increase availability of healthcare workers for performing COVID-19 duties. During the second wave, the government had also announced additional incentives for the health workers involved in COVID-19 duties, give preference in the form of up to 25% of the total marks for the respective recruitment examination, depending on the length of COVID-19 COVID duties rendered to healthcare workers who have worked on COVID-19 duties in government or private, including the private also, my lord, will kindly appreciate this. All private COVID-19 facilities for at least 100 days for appointment against regular government posts for any post recruited through NPSC, NSSB, or Department Recruitment Board during the year 2021 and 2022. By paragraph 4B of letter number so and so, dated 22nd March 2021. Then my lord may come to the next speech again, my lord.
No, doesn't talk about any benefit.
Your Lordship.
What benefits do you want?
The benefit is that, my lord, these special incentives were introduced because, my lord, we kindly appreciate this. Not only in Nagaland, and not only in India, but worldwide. So many health workers, they resigned. So to curb the fight against the COVID-19, my lord, and an extraordinary circumstance, special incentives were introduced, my lord.
No, that's what we want to see. Where are the incentives?
So your Lordship is that, my lord, the incentive is that 25%. Now they will get the special privilege of getting up to the benefit of 25%, my lord. And in a competitive exam, my lord, 25% is a huge increase, my lord. And it can ensure that if the posts are there, anyone can get qualified, my lord, because they are all qualified people, my lord. So this 25% incentive.
So it's in terms of marks.
Yes, your lordship. In terms
You
of
are
marks, it's
entitled to
for-
get 25% in the examination which is scheduled for regular appointment.
My lord.
If you show that you are a doctor rendering
And we have
service.
served. Yes, your lordship. Now, this incentive is not only catered to those who were in the government. In fact, the present petitioners who served under the government, even those who served under the private health facilities that were identified as the treatment for COVID-19 facilities, your lordship, they were also to enjoy this benefit. My lord, here what happened, the state wants to, in a pick and choose manner, they want to only give to few whom they have picked and choose. And we have.
Right, the pleadings are complete.
Yes, complete, and the petitioner, they cannot claim for regularization because there are no more in service. So where is the question of regularization?
Not regularization, it's about
Okay.
some 25%.
No, this is the earlier OM. Worship. If you see the cabinet.
We'll come back at 2.
Worship, I agree that this matter, because the cabinet decision has been challenged with another petition, so it has to be brought together and.
Yes.
Together.
On low points, yes, your lordship, it's a little connected.
All right,
But
at the request of counsel, senior government advocate, who submits that the benefits claimed by the petitioner under the cabinet decision
Yes, sir.
in the present writ petition. You write the cabinet decision basing on which the writ petitioners are claiming benefits in the present writ petition is put to challenge in another writ petition being WPC number
239 of 2024.
239 of 2024. Councils at the bar submit jointly that this writ petition, both the writ petitions will listed together. Is that matter fixed on any date?
No, that matter, on the last occasion, the notice was issued, so it is here to return. So, Your Lordship, this has to be done together and to be listed after 3 weeks.
So matters will be listed after 3 weeks.
Bless you, Lord.
Embassy adjournment with the confirmed hearing, na?
इसी के बारे में पूछा था रूल्स थोड़ा कुछ मुझे दो तीन ही नाम चाहिए हाँ बोलिए 40 नंबर है आइटम टू टेक अ पिटीशन का नाम की इसका एडवोकेट एम लॉक एम लॉक एम या 41 SMU government gets it.
Item number, yes, item number one is Mr. Ajo. No. Yes, no. The guy for responding number 6 is Aaron Long. Mr. Ajo, petitioner. Then Ki Angami respondent 1 to 5. Ki Angami. Respondent 1 to 5. Second. Yes. And then Mr. Aaron Long. Mr. AREN. Mr. AREN. Mr. Aaron Long responding number 6. Yes. I agree. Wednesday schema on the day.
Judge could. Judge. Judge's skin could. Judge itu different. Judge could. Judge.
For hearing, item number 14.
Yes.
beg to be item number 24. The middle might reach, so it's very maybe fix on 14, 11.
Mentioning hour is it in the morning, you should mention, might not reach, it will be leftover. If it is, doesn't reach, it will be leftover. But mentioning hour is in the morning. Item 44. Right, 44. Passed over. Adjourn to be listed after 2 weeks. At the request of counsel for the petitioner.
That case goes in after 3 weeks.
3 weeks. Yes. Yes.
May I please your lord?
Ah, yes.
My lord, I have submitted one short, my lord, written notes on my submissions, my lord. Along with, my lord, some judgments, my lord.
You have not even argued. What have you submitted?
Lordship.
What is your case that you are projecting here?
My lord, in para 20 of the writ petition, my lord, they have categorically stated that they filed an appeal, my lord, before the appellate authority, my lord. And I have specific instruction that appeal is pending and they didn't deposit even the pre-deposits, my lord.
Okay, this is in respect of
The same assessment order, my lord, which is challenged before this honorable court, my lord.
okay. Who's appearing for the petitioner?
My lord, I am here. My lord.
Yes.
Yes, my lord. I have already filed an appeal, and actually, your lordship will appreciate that affidavit in opposition filed by them.
Yes.
My lord, their affidavit in opposition that
No, first.
that page 4 para.
Mr. Paul,
My lord.
the court first. First, tell me what you are challenging, which order?
I am challenging the order, your lordship, that that assessment order made for the assessment in 2017-18.
Page number?
Page 70, my lord, 70.
70. This
70
assessment order.
is the assessment, your lordship.
Yes.
Assessment order.
Yes.
And demand, your lordship.
That's right. Now, against this assessment order, you already filed an appeal.
Yes, your lordship. Yes, your lordship.
Then how you can pursue two remedies, same before two different forums? Same remedy,
Now,
two different forums.
your lordship will appreciate that they are denying that in page 4 para 3, your lordship.
Denying what?
That I have not filed the appeal. That is why, your lordship, I have come before this honorable court. They are of their affidavit in opposition, your lordship.
Para 3.
Para 3, page 4
Yes.
of the affidavit. Should I read, your lordship?
They say that they have not, you have not preferred an appeal.
Yes, your lordship. And it is not correct that, your lordship, and I have already made my statement also, your lordship, and I have already that para annexure 14, your lordship, page 81 in my writ petition.
Yes.
I have already filed an appeal, your lordship, but there was no response from their side, your lordship. Otherwise, they are.
I am What is the position? Has the bill been filed or not?
Lordship, appeal was filed, my lord. I have, my lord, I have specific instruction, my lord. That they have filed appeal, my lord, but they didn't make the pre-deposits, my lord. And my lord, it was in our affidavit correctly, my lord, some preliminary objections was raised, my lord, on the ground that no appeal was preferred. However, my lord, regard to para 20, my lord.
Mr. Setia, you are aware of the procedure.
Lordship.
Tell us whether the authority is in session of the matter. Have they proceeded with the appeal or is it been dismissed?
No, it is pending, my lord. As on date, it is pending. Appeal is pending.
Appeal is pending.
My lord.
So the authorities are not taking up because they have not made the pre-deposit.
They have not made the pre-deposit.
What is the amount of pre-deposit to be made?
My lord, that is 20% of the disputed amount, my lord.
Where do you find it?
Lordship, pre-deposits, my lord, section 246, my lord, that is appeal, my lord.
246 is the provision for appeal, your lordship.
So what's the provision for pre-deposit?
Lordship, I'm coming to that.
Courtmaster, give me the income tax act.
My lord, here this is of Indian Income Tax Act, and this is a constitutional safeguard which is given to me, your lordship. Under Article 366, 25 MS Schedule Caste, Schedule Tribe, and this 1026 of Indian Income Tax Act.
Mr. Paul, please answer the question of the court. We are asking you, where is the provision for pre-deposit while filing?
My lord, since I am exempted from tax, I do not have that one, your lordship, regarding pre-deposit.
This is what you're challenging in the writ petition.
That one, your lordship, I have already, that pre-deposit, it is not under my challenge, your lordship. My challenge is wholly on assessment and demand.
That's right, but you have already preferred a department and appeal.
Yes, your lordship. Yes, your lordship.
How can you have two different forums? How can you approach two different forums simultaneously?
Now, your lordship, the appeal was pending and there was no response. There was no response from the department. That is why I have come before this honorable court, your lordship.
We'll direct the department to proceed with the appeal.
Yes, your lordship.
Of the act.
Yes, your lordship. And your lordship, my prayer before this honorable court that I should be exempted from pre-deposit, if any, during the.
No. You'll go as per the provisions of the act. You have to make the pre-deposit, whatever is there. We can't exempt you. That is why we wanted to see the statutory provision.
Yes, your lordship. Yes, your lordship.
Okay, heard. Mr. P.B. Paul, learned counsel for the petitioner, Mr. S. Setia, learned counsel appearing for the Income Tax Department. This writ petition is directed against the assessment order number so-and-so dated 31/3/2022. Page number 70. Whereby for the assessment year 2017-18. The proceedings initiated under section 147. Pursuant to issuance of notice under section 148 of the Income Tax Act, the assessments were completed by the assessing officer in respect of the writ petitioner, and a total amount of 3,17,17890,
890.
including including tax, interest, and penalty,
Yes, Your Lordship.
were found to be chargeable against the writ petitioner, and a demand notice to that effect was raised. Whereas the petitioner aggrieved by the assessment order, filed an appeal before the Commissioner Appeals, and it is the statement made by the petitioner, made by the counsel for the petitioner, that the appeal is presently pending, but no effective orders have been passed thereon. So the writ petition has been filed, praying for, under such circumstances, the writ petition has been filed, praying for setting aside the assessment order dated 31/3/2022, as well as the consequential demand. So standing counsel for the Income Tax Department submits that since there is already an appeal which is preferred against the assessment order, and the same is presently pending, the writ petition ought not to have been filed by the petitioner, as he had already taken recourse to the statutory alternative remedy prescribed. So under such circumstances, it is submitted that during the currency of the appeal, where no order has been passed, the writ petition is not maintainable, and the same should therefore be dismissed as not, as it is devoid of any merits. Whereas learned counsels for the parties have been heard, pleadings have been carefully perused. The department has also filed their affidavit and submitted that the appeal is pending, and during the pendency of the appeal, the writ petition ought not to be entertained. So learned counsel for the petitioner on the other end also urges before the court that the petitioner is an indigenous person belonging to a declared scheduled tribe, belonging to Khiam tribe, belonging to the state of Nagaland. So he refers to the petitioner is a permanent resident of Noklak in the district of Noklak, Nagaland, and is working for profit in the business of hardware and food grains. The learned counsel has also referred to the certificate of scheduled tribe issued by the additional deputy commissioner Noklak, which is enclosed as Annexure 1 to the writ petition. Stop. It is submitted that the petitioner is exempted from payment of income tax under section 1032. 1026, is it?
1026, Your Lordship.
Yes, 1026. 10 within bracket 26 of the Income Tax Act. Stop. Learned Counsel therefore submits that the assessment in the first place ought not to have been proceeded against the petitioner as he is a resident, as he is a member of a scheduled tribe belonging to the state of Nagaland, and which fact is not disputed by the respondents. Stop. He therefore submits that under such circumstances, he has challenged the assessment order dated so and so, whereby the assessing officer completed assessments under section 148 of the Income Tax Act, read with section so and so so and so. You will find it in page number 70, you will find this serial number 9, section 147, read with 144 capital B. So, be it as it may, counsel for the petitioner does not dispute his contentions, his averments in the writ petition, that the petitioner has already taken avail of the statutory remedy of preferring an appeal before the statutory authority, namely the commissioner within bracket appeals, the department, and the present appeal is still pending. Stop. Such averments and contentions raised before the court by the petitioner are also not disputed by the learned standing counsel for the Income Tax Department. So, under such circumstances, the petitioner having availed of the statutory remedy, this court, without the said remedy being without the said appeal being disposed of, and more particularly when the said appeal was filed at a prior point in time, prior to filing of the present writ petition, this court is disinclined to accept the contentions of the writ petitioner. Stop. It is therefore, the contentions raised by the writ petitioner can also be raised before the appellate authority, which is presently in session of the matter. So, we grant liberty the petitioner to file necessary applications before the Commissioner Income Tax Appeal, raising all grounds to assail the order, assessment order dated so and so, before the Commissioner appeals. Stop. The Commissioner appeals in its turn will proceed to hear and dispose of the appeal pending, appeal filed and pending, appeal filed by the petitioner and pending before the state authority as per provision of law. Stop. The petitioner is permitted 10 days time to file additional papers if you want. Mr. Paul?
My lord, 15 days.
2 weeks time to file all necessary papers as may be advised before the Commissioner appeals in support of its contentions, assailing the assessment order dated so and so. The Commissioner appeals will thereafter proceed to hear the matter and pass appropriate orders as per provision of law. we'll proceed to hear the matter as per provision of law and pass appropriate orders thereon. So, writ petition accordingly stands disposed of in terms of the above.
My lord, there was an interim order that may be vacated.
Interim order stands merged in terms of the order passed today in the writ petition.
Deeply obliged, ma'am.
For hearing, item number 33.
appeal করো না।
Yes. Mr. Jamil.
A brief summary, Lordship. All right. One with the petition. The petitioner was appointed as a computer in the Economics and Statistics Department. And then while working as such, he was taken to the Department of School Education as a postgraduate teacher on petition for a period of 2 years. And during these 2 years, he got regularized in the post of his parent department, that is computer. During that time, during the period of 2 years of deputation, he was not reverted back to the parent department. So ultimately, he got absorbed in the school education department in the post of postgraduate teacher, in short PGT. And he obtained PhD degree from 2 universities. One is from Meghalaya and the other is from Kanpur. That was a correspondence course. He enrolled in the Gauhati Center without knowing that that is not a recognized institute. However, the other certificate which he has obtained from Meghalaya, that is genuine and valid. And the purpose of pursuing the PhD degree in the Kanpur was for enhancement of his intellectual capacity. Now, there was some problem with regard to his seniority, whether it should be counted from the date of cabinet decision.
Which certificate is not genuine?
The one which he has obtained from Sejin Kanpur.
Kanpur.
Yes. Now,
Yes.
he got absorbed in the school education department, and then there was some problem with regard to the counting of seniority, whether it should be counted from the date of cabinet decision or it should be counted from the date when he was absorbed in the PGT. So he filed a writ petition that was disposed of in the year 2013, holding that the seniority of the petitioner shall be counted from the date when he was appointed as a postgraduate teacher, that is 2003. So during that time, it so happened that the cases for promotion was considered to the post of principal. And since his seniority has been determined in terms of the date of joining in the postgraduate teacher, he was given promotion to the post of principal, based on the order passed by the Honorable Court in 2013. And during that time, some complaint has been lodged before the Lok Ayukta by some candidates who were selected through Nagaland Public Service Commission between 2004 and 2008. And actually, these persons who have lodged a complaint to the Lok Ayukta ought to have challenged the order passed by this Honorable Court if they are aggrieved by that order, because that has recalled the seniority of the petitioner with effect from the date of appointment of PGT. So, Lok Ayukta, they have filed a complaint before the Lok Ayukta. So, Lok Ayukta has taken up the case, and an interim direction was issued to the School Education Department, directing that the promotion, officially promotion given to the petitioner should be cancelled. Very quickly, after getting the intimation from the Lok Ayukta, the Department of School Education has cancelled my officially promotion, which was given to the post of principal. So, agreed by the said order, the petitioner is before this honorable court on the ground that the Lok Ayukta do not have the jurisdiction to investigate the case in a service matter in view of Schedule 2. Number 2, under Section 9 of the Nagaland Lok Ayukta Act 2017, the Lok Ayukta do not have the jurisdiction to investigate when the investigation is pending before another forum. In other words, if there is alternative remedy, other forum to adjudicate, then Lok Ayukta do not have the jurisdiction to investigate the matter. Now, in my case, just because Lok Ayukta has taken up the case and then a recommendation was sent to the School Education Department to cancel my promotion that was suddenly cancelled based on the recommendation made by the Lok Ayukta. Lok Ayukta Lordship knows it is only a recommending body. And when inquiry is pending in the parent department, they could have waited for the outcome of that inquiry and any penalty, if deemed fit, can be imposed on the basis of the inquiry conducted against the case. So that is the short parameters of the case. We are questioning the jurisdiction of the Lok Ayukta, and my promotion was given on the basis on the order passed by the Honorable Court in 2013. And unless and until that order is reversed or modified or reviewed, my promotion should be not with that, because it is based on the order passed by the Honorable Court.
Which is that order?
That is at page 45. No, sorry. I think it's. Similar.
45, I think there is an order of the court.
Page 26. Election Act. This is 17 July 2014. And this is subject to regularization by the BBC. Now, they have enclosed the annexure, the list. Annexure A. Can we come to page 27? Page 27. This is continuation of the promotion order launching.
Where is your name?
Serial number 1. Shri Y. Fantomo Kibon. Designation PGT. Present place of posting is Government has Higher Secondary School Oka. And the extreme right column launching. Promoted as principal in compliance of Honorable High Court Kohima, each in case number WBC 107K of 2012.
Where is that order?
That order is at page 45.
45.
This is just an extract by the Lok Ayukta, but this is the content of the order launching. Since this order is also enclosed in the affidavit, but for easy reference, let me rely on this.
Yes.
May I read, Lordship? This
Yes.
is 4/9/2020. This writ petition under Article 226 of the Constitution of India has been filed so as to challenge the notification dated 9/1/2012 issued by the Commissioner and Secretary, Department of School Education, Nagaland, whereby the writ petitioner has been absorbed as a postgraduate teacher with effect from the cabinet decision dated 18/1/2011 and not from the date of his training as a postgraduate teacher in the same department. Third, Shri Zatin Moli, learned counsel appearing on behalf of the petitioner as well as Lucy, learned counsel appearing on behalf of the petitioner as well as so and so. Three, the petitioner's case in short is that he was earlier appointed in Economics and Statistics Department. Subsequently, he was sent to School Education on deputation, white number dated 34/20/2003, issued by the Department of Education. The period of deputation was for a period of 2 years. However, even after completion of the deputation period, the petitioner was not reverted back to his parent post. In fact, the writ petitioner continued in the Education Department, and after 6 years of service to the Education Department and with due consent from the parent department, the petitioner was absorbed in the Education Department by notification dated 14/2/2011. As per this notification, the seniority of the writ petitioner was directed to be counted from the date of his training as a postgraduate teacher, that is 30/4/2003. On the basis of this notification, a tentative seniority list of the officers of the Government Higher Secondary School was prepared and published in the month of November 2011. In the said seniority list, the petitioner was shown at serial number 19, and his date of training in the Government Higher Secondary School was shown as 2/5/2003. Subsequent to the publication of the seniority list, the government has issued a government notification dated 9/1/2012, declaring that the seniority of the writ petitioner will be counted from the date of cabinet decision dated 18/1/2011 and not from the date of training as the postgraduate teacher. This is the dispute portion. The learned counsel for the petitioner further submitted that similarly situated persons were absorbed in the retrospective effect, at least instances of 2 postgraduate teachers, namely Shrimati B. Watisanga and Shrimati Ingungwa, have been cited before me. These 2 teachers were absorbed from the date of their training in the Education Department on deputation. In this way, there appears to be a discrimination with the writ petitioner. 5. The government's stand is that the earlier notification dated 14/2/2011 was issued inadvertently without following any formal procedure and practice. However, it is not made clear in the affidavit as to on what basis the earlier decision to absorb the writ petitioner retrospectively was taken. Besides this, the state affidavit is also not clear as to why the decision of the cabinet to absorb the writ petitioner prospectively and not retrospectively was taken. The office memorandum dated 12/8/1975 referred to by the learned common council is not applicable in the instant case, and as much as the writ petitioner was regularized in his parent department itself. 6. In the case of A.S.I. Roblal versus Lieutenant Governor, AIR 2000, Supreme Court 594, the Honorable Supreme Court has held that any rule, regulation, or executive instructions which has the effect of taking away the service rendered by the petitioners in an equivalent manner in the parent department while counting the seniority in the deputation post would be violated relative of Article 14 and 16 of the Constitution. 7. In view of the aforesaid facts and circumstances of the aforesaid of the case, the MBO notification dated 9/1/2012 is hereby set aside. The respondents are directed to consider the seniority of the writ petitioner on the basis of the earlier notification dated 14/2/2011, that is 30/4/2003. That is the appointment as PGT on the petition. And 14/2/2011 is date of absorption. And so this is the direction of this honorable court. And based on this order, the promotion was given.
This 9/1/12 is pursuant to some what cabinet decision.
Yes.
Cabinet decision.
This actually, this is 9 is timing mistake. It should be 18. That is the date of cabinet decision.
Cabinet
Notification.
Cabinet decision is 18/1/2011.
Yes.
And the date of the order is
Date of appointment.
the absorption
Cabinet
order.
decision.
No, absorption order is which date?
May I refer from the beginning? All the comments and close. Absorption order is in page 25.
No, we are trying to understand what is the direction of the court.
Direction of the court is lordship. The kindly turn to the next page,
Yes.
47.
Yes.
There, lordship will find the notification. 9 January 2012. The cabinet decision has made it 18/1/2011. By this 9 January 2012 order.
No, I'm sorry, where is the 9 January?
Notification.
Ah.
It's not given, but below it is written as
29?
29.
Ah.
But it appears to be a timing mistake. Should be actually 9,
9, okay,
going by other agreements.
okay.
This notification was the Indian order in the writ petition, that is WPC 107K of 2012.
Okay, now, where is the order of the Lokayukta?
Local. This is a part of the Lokayukta order. Page 41.
14.
On one hand, the Lok Ayukta is saying that the court order, high court order still stands. On the other hand, again, he is saying that officially promotion has been given by misinterpreting the court's order. But whether it is the Lok Ayukta is committed to decide such an issue, the seniority dispute in the Department of Qualification, whether the Lok Ayukta can go through all this investigation. And admittedly, the inquiry is pending. In the School Education Department.
No, so the writ court has merely directed his seniority to be counted from that particular date
Yes, 2003.
as postgraduate teacher.
Yes.
Now Lok Ayukta has done what? Interfered with his promotion as principal.
We have sent a recommendation that the official promotion has been given by misinterpreting the court's order. But Lordship, you can see page 42 last paragraph. 42 last paragraph.
Page 42.
None including the complainants have gone on appeal against this order. As such, the court's order stands. Very clearly, yes mentioned. And on the other hand.
No, what I want to know is, the court's order is with regard to the question of his seniority. Nothing to do with his promotion.
Yes.
The seniority.
Yes.
That has been sustained by the court.
Yes.
Right or wrong, it has not gone in appeal.
Yes.
Now, subsequently, he was recommended for promotion
Yes.
to the post of principal,
Yes.
which somebody complained before the Lok Ayukta, and they recommended that the department shall review the
Yes.
officiating notification.
Happily complied with the recommendation of the Lok Ayukta. Actually, School Education Department would have said that who are you to direct us to whether to cancel or to give promotion to a particular employee. But looking at the entire picture, it appears that 2013 judgment ought to have been challenged by if anybody is agreed, but nobody has challenged.
This officiating promotion notification dated 17/7/2014
Yes.
is for what?
17
Promotion to which post?
2014. Principal. To the post of principal.
Principal.
And that promotion is given based on the order passed by the Honorable Court. It is clearly mentioned in the order itself. And nobody has challenged. So my plea is, my submission is, when the promotion has been given based on the order passed by this Honorable Court, unless and until the foundation is removed, it should stand. That is my submission, Lord. And since they have not challenged this order, in the later day, if they challenge, there will be some problems. So, brilliant idea struck in mind. Let us go to Lok Ayukta and let us start some fresh investigation so that
You're saying that Lok Ayukta does not have the
Yes.
jurisdiction. Let us
Yes,
have a look
you
at
do not have the jurisdiction.
You have the Lok Ayukta Act.
Section 9.
Section 9.
Yes.
Yes.
9, section 9.
Yes.
Matters not subject to investigation. 1. Except as herein after provided, the Lok Ayukta or Upper Lok Ayukta shall not is very important, shall not conduct any investigation under this act in the cases of a complaint involving a grievance in respect of any action. So involving a grievance, here is a grievance. Because my learned friend, we argue that no, there are distinctions between a complaint and complaint involving a grievance. Involving a grievance. A, if such action relates to any matter specified in the second schedule. Second schedule, I will take your lordship later on. Or B, if the complainant has or had any remedy by way of a proceeding before any forum or other authority. So if there is any other forum or authority, if the complainant has such forum, then they could have availed that. Now, what prevented the complainants to approach the competent authority, that is the school education department, about this? And only when they exhaust the remedy, then they may resort to other alternative if permissible under the law. So A and B, and put count. B, there is a proceeding pending in the school education department. Memorandum has already been issued under Rule 4 of the Nagaland Government Service Conduct Rules. It is already issued by the school education department.
To what effect?
To conduct an inquiry against the petitioner. So admittedly, the inquiry is pending, number one. Number two, coming to A. If such action relates to any matter specified in second schedule. So what is the second schedule? Let us kindly come to page 27. Second schedule. Pages are given in the bottom of the page.
Yes.
I am referring to the second schedule. Action taken in respect of appointments, removal, pay, discipline, superannuation, or other matters relating to conditions of service of public servants. This is important, but not including action relating to a claim of pension, gratuity, provident fund, or to any claim which arise on retirement, removal, on termination of service, and such other action involving allegation of corruption in respect of appointment not part under the provisions of section 35 of the Act. So, Lordship, Upper Lok Ayukta or Lok Ayukta is basically for to check the corruption among the civil servants. Their basically duty is to check all this corruption cases, not to do with the service matters as has been done now. So on both counts, Lok Ayukta do not have the jurisdiction to investigate this in a service matter. That too, a seniority issue.
Yes. Okay.
So, Lordship, in view of all this, the impugn order which has been passed, that is on 24th March 2023. This page 66, this order in clear terms, order has been issued cancelling my promotion on the recommendation of the Upper Ayukta, who do not have the power to investigate.
Where is the order?
Page 66, last page.
66.
In the petition lodge. Since I'm reviewing this, I may be allowed to read this order.
But this is an interim recommendation.
Interim recommendation, yes. Whether it is interim or final, when you do not have the jurisdiction, what authority, what power do you have to recommend? Even you don't have this interim recommendation power. If you have the authority, yes, you can pass any type of order. But you do not have the jurisdiction and power to investigate when the matter is pending before another forum. Secondly, it is a service matter where the Lok Ayukta do not have the jurisdiction.
What is the status of the inquiry in the department?
Inquiry show memorandum has been issued, but thereafter nothing I have replied. It's enclosed at page 51.
Okay.
Petitioner has, page 56. Page 56. 28 May 2022. And I have filed reply to this. That this statement has been filed as instructed by the and what has happened. The possession is now.
Yes.
Now, this Indian order has the basis on election or page 41.
Yes.
That is the order which Lokayuta has passed. So the relevant issue is whether they have the jurisdiction or not. My submission is, no, Lokayuta or Opa Lokayuta is only a recommending body. They have no jurisdiction to direct the controlling department to recommend any penalty also. Moreover, the departmental inquiry is pending. Let any decision be taken pursuant to the outcome of the inquiry which is being pending against the petitioner by the parent department, not the Opa Lokayuta. And so far as the official promotion is concerned, this is pursuant to the order passed by this Honorable Court on 4/9/2013, passed in Petition number 107 of 2012. And the official promotion, the High Court order, which has been passed on 4/9/2013, is the basis. And unless the order passed by this Honorable Court is reversed, official promotion cannot be revoked. Petitioner has submitted presentation also for confirmation of his promotion, because unless the promotion, official promotion is confirmed, then it cannot be given the pay scale of the principal scale. That is also not considered, that is pending. So my official promotion is subject to the approval by the recommendation by the departmental promotion committee. That has not been done. And all my original documents have been seized by the Lokayuta, and it is pending with them. So all these documents should be released, since they do not have the jurisdiction. They will take it as a satisfactory. The issue is pertaining to the seniority only, which has been determined by this Honorable Court. That is my submission, and I will just give short reply after I learn it, make the submission. And before that, Lordship, in a similar case where the issue of investigation by the Lokayuta has been raised, my counsel for the Lokayuta has tried to make a distinction between in the definition of the inquiry, investigation. The investigation involving a grievance and just a mere complaint. So if there is a grievance, complaint is with a grievance, then yes, Lokayukta can. Because from the affidavit of the private respondent, this clearly meant of the grievance is their seniority.
Yes.
Therefore, the action is ordered to by the Lokayukta. It's based on extraneous consideration and the pressure given by the private respondents who are directly recruited through NPSC between 2004 and 2008. They have not challenged the judgment passed by this honorable court on 4th September 2013. And they found that this will be the best approach so as to notify the court order to overcome the court order. I think that is the possible objective they have done. I conclude with that.
Any authorities in support of your contentions regarding the scope and ambit of inquiry of Lokayukta?
The investigation by the Lokayukta, which can be done, which cannot be done, involving a grievance or not. Paragraph 4, 6, 7.
Wait, let us go through paragraph 4. Yes. No, you take us to the finding of this.
It's a short judgment also. Paragraphs are also short.
Paragraphs?
4,
4.
4, 6, 7, 9, 14 and 16. Paragraph 4, 6, 7, 9, 14 and 16.
What is the conclusion reached?
Conclusion is page. If there is, if procedural grievance is involved, then Lokayukta will not have the power. But if it is just a complaint without any grievance, then Lokayukta will have the jurisdiction to investigate. That is what the submission was made. And this honorable court has accepted that contention in the writ appeal. And the affidavit of the private respondents, respondent number 4 to 9, 5 to 9, has clearly stated in your affidavit that because of this grievance in the seniority, they have lodged the complaint. So this judgment will cover this case also.
What is the finding in para 16?
The bar of investigation is only a measure not to get the Lokayukta loaded with complaints involving grievance. So if there is grievance, then they cannot investigate.
You read
We're
further.
dealing with those matters mentioned in second schedule. So second schedule, service matters, all these are there. We are getting out the matters under schedule number D. Second schedule, with section 9 of the Act of 2017, would show that those matters are necessarily pertaining to party involved. Anything to do with his appointment, removal, pay, separation, etc. It is only when a party who is aggrieved by any action, this is very important, any action pertaining to any matters mentioned above, that such a complaint is part under section 9.
What is the meaning of that?
If the complaint is with any grievance, if I raise some grievance in the complaint, stating that I'm affected by this, then that is a grievance. And when a grievance is involved in a complaint, Lok Ayukta will not have the jurisdiction. That is what it means. But if it is only a complaint without having any grievance, then Lok Ayukta will have the power. If I lodge a complaint with some grievance, that investigation is part, because there will be
No, grievance against whom?
grievance against anyone. If personal grievance is involved, then if the Lok Ayukta started entertaining all this kind of complaints, they will be floated. Therefore, in order to prevent that, any complaint involving a personal grievance, then no investigation. It is part. But if there is no grievance, personal grievance, the complaint is filed, maybe like sort of a public interest litigation, all that. Corruption cases, that in so department, so much of money has been misappropriated, this may be investigated. Those investigations can be done. It has got.
That interpretation perhaps does not fall from para 16. Para 16 is when third party raises an issue, there is no bar. But if the person concerned comes before the Lok Ayukta, raises an issue, then it is barred.
In the act, there is nothing about third party.
Well, this is the division bench.
Our case is a complaint lodged by aggrieved party, and therefore it is part by section 9.
No, here aggrieved party, if I have understood, aggrieved party means, as sought to be explained by the division bench, means the writ petitioner. Aggrieved party means, supposing you are aggrieved, you are before the court, before the Lok Ayukta, saying that my promotion not given, salary this, that, whatever it is, then it is barred. But if there is a third party making this allegation, in your case, who has referred it? Who has referred this?
It is private respondent number 529.
Okay. So they had
a grievance.
No. Who lodged the complaint?
Private respondent.
Which private respondent?
They were not initially indicted as party, but by a subsequent order, they filed an application for indictment, and they are indicted as respondent number 529.
Okay.
They are a
So
person.
they lodged the complaint.
Yes, because the order passed by this honorable court on 4/9/2013 has made me senior to them. And they have failed to challenge that order. And they are still curious. Therefore,
Private respondents 4 to
9. 5 to 9.
5 to 9.
If they have any grievance with regard to the seniority, then they could have challenged the order passed by this honorable court, because my seniority is conferred by the order passed by this honorable court.
So according to you, findings of the division bench will be applicable.
Yes.
In this case.
Yes.
Because they are lodged by persons who are aggrieved by any action.
Yes.
Pertaining to any matters prescribed under section 9.
Kindly come to the affidavit in our session of question number 5 to 9. I will just refer to the relevant portion.
One minute.
reason for lodging the complaint is mentioned here. Affidavit in opposition of respondent number 5 to 9 at page 5, Roman paragraph 5.
Roman paragraph.
5. That's correct.
Sorry.
Page 5.
Yes.
Roman 5. Here. This is the reason for lodging the complaint with a grievance. This is the statement.
Okay.
The present respondent, while pursuing their rights, affected A, starting with A, affected by the illegal promotion of the petitioner. It has come to your knowledge that the VH certificate possessed by the petitioner and submitted to the authorities are also fake certificates. It is stated that VH certificate is mandatory to hold the post of vice president and at a higher post. The present respondents therefore lodge a complaint against the lead petitioner to the Secretary, Nagaland Law Ayuktha on 25/6/2020, saying for investigation and examination inter alia of illegal promotion and submission of fake PH certificate by the lead petitioner. Now,
yes,
whether the promotion is rightly given or not. This is one of the conditions of service. Promotion, demotion, upgradation, all these are conditions of service. Seniority is also a condition of service. So, they have lodged a complaint having affected by illegal promotion of the lead petition.
yes,
So, if they are agreed by the illegal promotion of the lead petitioner, what prevented them to approach the Honorable Court also? Or they find it easier to make the law like that and then make some arrangement and then file the complaint and allow the law to decide when he do not have the jurisdiction? What prevented them to approach the Honorable Court, come with a front door and then make your submission? This is my preference. This Honorable Court will either allow.
maybe they were scared of you. Therefore, they did not come to court. Yes.
Because of maybe apparently because of the delay. They have been sleeping like Reef Van Winger and then woken up from the slumber at the late of the day.
When you became a principal.
And they are raising objections that no, in order to get promoted to the post of principal, actually he should be promoted to the post of vice principal as per the rules. Role came in 2017 only.
Okay.
And the promotion is rightly or wrongly based on the order passed by the Honorable Court. So the very foundation of my promotion can be changed only when the basis is removed. And how to remove the basis? There are ways and means. But they have approached the wrong form of action. And because of that, I have been victimized in so many fronts. That is how I have approached this.
Yes.
My short submission.
No other authorities.
No other.
Yes.
May I please, Lordship? Your Lordship, and remain for a form. The land looks like that. And this petitioner is questioning my jurisdiction. My submission will be confined to the jurisdiction of the petition. Now, like every state local, including the local term, Assam's local term of the Act. The Nagaland Local Act 2017 also specifically provides for two categories of claim that can be investigated by local dialogue. May I take your Lordship to section 10?
Yes.
Section 10, your worship, that's what it
Yes.
Yeah. Subject to the provision of this act, a complaint may be made under this act to the local actor in the case of an allegation by any person, your worship, not third party, by any person, your worship may kindly mark that. And in the case of a grievance by a person agreed, your worship.
Yes.
So a complaint can be either a complaint involving grievance, which can be made only by the person agreed, or a complaint involving allegation, which can be made by any person. Now, so there's a clear distinction between the two categories of complaints, and your worship mechanism, section 9(3) also, limitation period is so provided. Section 9(3), just on top. Worship has got it. 9(3), same page. The local authority shall not investigate a complaint involving a grievance made after the expiry of the period of 12 months and B, worship. So any complaint involving an allegation made after the expiry of 5 years from the date. So your worship, these two are two distinct categories of complaints, your worship. Now, may I take your worship to section 9, section 9. Your according to the petitioner, local does not have jurisdiction under section 9(1)(8), right with clause D2.
Yes.
Should section 9.
Yes.
Except as here provided, the local shall not conduct any investigation under this act in case of a complaint involving in underlined.
Yes.
In case of a complaint involving grievance in respect of any action.
Yes.
That is second schedule. Lordship is the legislative council has taken your worship to cross to schedule 2, condition of service. But here, what is barred by such under section 9 is complaint involving grievance. And there are two categories of complaint. Now, the issue involved in this petition or worship in my submission, whether in a complaint involving a grievance and also an allegation, whether such complaint will come within the ambit of section 9(1)(8), right with clause D2, schedule 2. Why I say so, your worship? May I take your worship to the complaint? To the complaint, affidavit of opposition filed by respondent number 5 to 9.
No, first let us understand what is the import of section 9.
Yes.
Read with the schedule.
Yes. So what is barred under section 9(1)(8), read with clause D2 schedule 2 is complaint involving grievance.
What is a complaint involving grievance?
Your worship, complaint involving grievance in matter relating to matter, your worship, to schedule 2.
Yes.
Where supporting if it relates to appointment D, clause D, removal, pay, discipline, subordination or other matter relating to condition of service. Here in this case, your worship, the grievance of the complainant, one of the grievance was that because of the promotion given to the petitioner, like he has been superseded, he has superseded the petitioner. That is the case, your worship. That is the grievance. And that one, there is also another element, allegation. Allegation is that by submitting fake DLX certificate. So that is an allegation. So in a complaint which involves element of grievance and allegation, whether such complaint will come within the ambit of section 9(1)(8), read with clause G2, schedule 2.
You'll have to interpret the definition, taking into account the judgment of the division bench.
Lordship. No, going by the act. Now, complaint allegation involving allegation can be made by any person. Section 10, Your Lordship. Whereas in case of grievance, it can be made only by the person who is aggrieved.
This is exactly what division bench says
Yeah.
can be done. Division bench has interpreted to say, if it is made by a third party, you can do it. But if it relates to, even if it is a third party, even if it pertains to the service and promotion and appointment, Lokayukta has the jurisdiction to do it. But if you are a person aggrieved directly, then you can.
No.
That is what I understand.
What is barred under section 9, Your Lordship, is only grievance, not allegation. Can I take Your Lordship to section 9 again?
Yes.
Except as hereunto provided, the local developer shall not conduct any investigation under this act in the cases of a complaint involving grievance. So clause G to schedule 2 has to be read with this.
No, then you have to read section 10 also.
Yes. Now coming to section 10. Section 10 says that there are two categories of complaint. One is complaint involving grievance, and another is complaint involving an allegation. Whereas complaint involving an allegation can be made by any person. Complaint involving grievance can be made only by the person aggrieved. Now, when section 9 specifically says that, and when these are
But let me ask you something. Assuming the petitioner's promotion is interfered with, as has been done now, does it not stand to benefit the respondents? It will benefit him. If the order of the Lokayukta is to be implemented, and his original position in the seniority list is interfered with, etc., it stands to benefit the respondents.
Yeah, Your Worship. The issue before the brief court, judgment of which was relied upon, that does not relate to fake certificate. What is under investigation before the local?
See,
fake certificate.
The problem is statutes can be interpreted. Judgments cannot be. Judgments you'll have to read the way they are. Even a very categorical finding to say that if it is by a third party, you can do it.
But third party, but it does not say that but except third party. It does not say that except third party.
It is only when a party who is aggrieved by an action pertaining to any of the matters, such complaint cannot be lodged. So the respondent is undoubtedly aggrieved by an action taken in favor of the petitioner, which is otherwise barred in the second schedule.
Your Lordship, your Lordship may clearly see whether the complaint in question, that is why I wanted to take your Lordship as a complaint, whether the complaint in question is a complaint involving grievance, so as to attract section 9. If it is not complaint involving grievance, then section 9 will not be attracted.
Okay.
But in my respectful submission.
Where is the complaint?
Complaint, Your Lordship. Affidavit of origin, file response number 5, signed, Your Lordship, page 22.
Page 22 of the affidavit is the possession of response number 5 to 9.
Yes.
Lordship has got it.
Yes. Annexure C.
And yes.
Yes.
With reference to the merit.
Yes.
Complaint against such and such, who is the petitioner here. Sir, with reference to the subject cited above, The undersigned on behalf of NPSC 2004 and 2008 batch of PG teachers, postgraduate teachers of the Department of School Education would like to submit the following complaint for your kind investigation and rectification thereof. See where Bantomo Computer in Economics and Statistics Department joined the school education as PGT, postgraduate teacher within bracket history on education by order such and such. He was rigorous as computer in his parent department only after joining school education department on 30 June 2003 by order such and such. His service was absorbed in the school education department in 2011 by order with effect from the date he joined as postgraduate teacher on deputation, which was later corrected by order dated such and such, where his seniority was affected from the date of cabinet decision, that is 18/1/2011. However, his seniority fixation was made from the date of joining as PGT on deputation, based on the court ruling order dated such and such, which was against the PNR standing rules, which should be from the date of absorption. See why Bantomo was promoted directly to the post of PGT from post of principal from postgraduate teacher in 2014 by order such and such. This double promotion was given, though he does not have BL, which is a prerequisite requirement for consideration of promotion to higher post from PGT as per the Nagaland School Education Service in 2002. He was again promoted to senior principal such in Government Higher Secondary School Gauhati by order such and such. It is learned from the promotion of stream such and such was made as per his BEd certificate, which he produced in 2016 from this University in Kanpur. We, the undersigned, on behalf of the aggrieved party in this matter, would like to bring to your knowledge the following anomalies from his BEd he has submitted to declare his seniority and subsequent promotion. Number one, discrepancy in form number in his admit card from the BEd first year and second year 2015 first year. His form number such and such was this. Number two, totaling of marks is wrong in part one mark sheet. Actual total in Bible such and such. Thus, grand total is strongly shown as this, though it should be this. Number three, signature of the register in its BEd pass certificate and statement of mark is different. Four, date of result in the mark sheet is 19th September for the first year and second year, which is very unlikely for a university to be declaring the marks on the same date every year. As per the university website, BEd result of Chhatrapati such and such was declared on this. Five. Now the university Kanpur, UP is not recognized to offer BEd through system education by National College of Physical Education. However, he has enrolled as a private candidate, which is not permissible. On checking through the university website, his phone number was not found. Moreover, there is no BEd course in both regular and private option in the BEd result is for other stream, that is art, science, and commerce.
You come to the last paragraph. Sorry to interrupt.
His phone number was found.
Yeah. You come to
Was
the
not
last.
found was due to the years mentioned, etc. Now, these are all allegations, Your Lordship. May I take Your Lordship to page 25? Is the affidavit.
No, you come to this. Page number 23.
23.
You read this second paragraph.
Lordship. We the undersigned.
We the undersigned.
Yes. On behalf of the aggrieved party.
On behalf of the aggrieved party.
Yes. So on behalf of the aggrieved party, they
Now-
have not the allegation.
No, now you come to the last paragraph on page 24.
Therefore, we the undersigned. Lordship.
On behalf, yes.
On behalf of all this and this report, whose seniority has been superseded, request of esteemed authority for thorough investigation and examination of this matter.
Right.
So that his promotion case will be reviewed.
So all the PGT teachers
Yes.
are aggrieved.
Yes.
They are filing this in a representative capacity, but they're also aggrieved.
Now, in this connection, Your Lordship, may I place Your Lordship a case for Your Lordship?
Yes.
Yeah, as I've said, every state local that has similar provision from which local can investigate complaint involving grievance and complaint involving grievance and allegation, Your Lordship. And the High Court, Your Worship, had an occasion to examine one such matter, Your Worship. I have just given 3 cases also, Your Worship. This case, Your Worship, dishwasher of Chudaman Party versus local state of Maharashtra.
Yes.
Lordship recorded. At the bottom, this order was passed in petition 3169. Below this one. May I take your worship to para 16? Para 16 is relevant paragraph of the worship.
Yes.
The British expression used in the Act, grievance whatever, is may not be relevant. Now, next page 63, Your Worship. 63, Your Worship. Kindly next page. Para 16 continuation. Starting from in section 7, second para, Your Worship. Section 7 enumerates the matter which may be investigated by the local or the local authority. Then comes section 8, which is as under. Similar provision, except as hereinafter provided, the local or local shall not conduct any investigation under this act. In the case of a complaint involving grievance, in respect of any action, if such action relates to any matter specified in 3rd schedule, here in this case, Your Worship, it's 2nd schedule, Your Worship. In Assam also, I think it's 2nd schedule, Your Worship. So similar provision. Now, may I take Your Worship to para 17.
Yes.
The main contention raised before us as well as before the local was regarding the jurisdiction of local to entertain the complaint filed by Dr. Mutolkar. It is not necessary to make a detailed reference to the accounts or allegation made in the complaint, since they are properly catalogued by a local in para 5 of this order dated this, which reads as under. Number 1, Dr. Biswa Chudaman has been called for interview for the post of additional honorary pediatrician in the Government General Hospital at India, although he was not eligible or qualified for the post. Number 2, respondent 1 to 3 have issued GR number such and such by abusing their position, Your Worship, as public servant in order to ensure selection of Dr. Biswa Chudaman. 3, the certificate and testimonial produced by the complainant were not considered and no marks were given to him. And number 4, the certificate produced by such and such, however, considered without proper evaluation and marks were given to him. Reading the allegation, Your Worship, made in the complaint, it can be said that the averment made in Sapara 1, 3, and 4 might fall within the area of grievance. However, the averment made in Sapara 2 about the abuse of position by the public servant, in this case, it's from its fake certificate, to favor the petitioner squarely falls within the scope of the term allegation as defined in the Act. Subsection 2 takes it import upon averment. The averment made is also covered by the definition such and such. Therefore, in any case, this is one of those cases where it can be said that the averment made in the complaint are overlapping and cover the area and field of allegation as well as grievance, Your Worship. Now, 18, Your Worship.
Yes.
In our opinion, it is not necessary to decide any wider question in this petition once it is held that the complaint file was overlapping. The question has come down to 5 lines below. Therefore, the averments are overlapping and amounts to allegation as well as grievance. And therefore, it cannot be said that the view taken by the court that the said complaint was not barred under section 8(1)(a). In our case, it is section 9 of the Act, was in any way reverse or wrong. Now, in my respectful submission, Your Lordship, this is also a complaint where both overlaps a grievance and also allegation. There's an overlap of grievance and allegation, Your Lordship. And when there is an overlapping of grievance and allegation, your lordship, that will not come within the ambit of section 9(1)(a), graduate clause G2, schedule 2, your lordship. Now, your lordship, since I relying on the judgment passed by Maharashtra, another high court, your lordship, the third judgment act, which I have furnished your lordship, that is 2008-14 SCC 283, your lordship.
So you're submitting that if there is overlapping.
Yes, then it will not attract, it will not come, the complaint will not come within the ambit of section 9(1)(a). And there, because what is exclusively part is only complaint involving grievance. And your lordship, in all state Lokata, be it Maharashtra, even state, Assam state Lokata lordship has similar provision, your lordship. If there is an overlapping of grievance and allegation, your lordship. Now, in this case, so far as supersession is concerned, promotion is concerned, that is a grievance of the petitioner, of the private respondent. But at the same time, your lordship, an allegation has also been made as regards submission of fake BL certificate, DLS certificate, which is BL certificate, your lordship, which is under investigation, your lordship. So, in case where there is overlapping of allegation as well as grievance, that will not come within the ambit of section 9(1)(a), your lordship.
Yes.
Now, on judgment passed by another high court, your lordship.
Just a minute. What will be the citation here? 85 ml JH ml MHLJ.
Lordship.
Page number 54. LJ. Yes. Okay.
And on judgment passed by another high court, your lordship, practice judgment has case, which is imported in 2008, volume 14, SCC 283. It's para 23, your lordship. Para 23, your lordship has got it.
Yes.
The third line, your lordship, last 3 lines. The judgment of other high court, though not binding, your lordship.
That for that you don't require it.
Lordship, just and
that you don't require.
And the lordship.
Is there any other issue you want to?
And any other issue?
No, from this judgment, from this Pradeep Mehta.
No.
Only for that purpose.
Only for that.
Not necessary.
And
there's no quarrel on that.
And on jurisdiction by submission, and your lordship petitioner has also challenged the notification, which is page 66 of the writ petition.
No, there is another judgment you have given.
Yeah, I'm coming to that, your lordship.
Okay.
Before that, may I take your lordship to page 66?
66.
This is the order passed by the education department, your lordship, the last page.
No,
The writ
6 of the writ petition.
Writ petition. The last page. By this order, your lordship, the page 66, the last page. Writ petition. By this order, the official permission given to the petitioner was revoked, your lordship. Now, this is an order passed by the school education department where I actually look like I have nothing to say. But your lordship, may I just read out the third line, 3 lines. In presence of the interim recommendation order passed by Honorable Lokata dated 28/2021. This order has been passed by the school education based on the order dated 28/2021, your lordship. But The order, this order is not being challenged, Your Lordship, in this petition. So that is why my third sub.
Which,
The order dated 28/2021. And which is annexed in page 41 writ petition. They have annexed it.
just 1 minute. Order dated 28/9, sorry.
20/08/2021.
This is the interim recommendation.
Yes. And this is not being challenged, Your Lordship, in the prayer, Your Lordship, this is not being challenged. And that is why, Your Lordship, my third case law, Your Lordship.
Just 1 minute. This is enclosed at which page?
Page 41, which in fact was read out to Your Lordship also.
Ah, yes, yes.
Yes. So this
No,
order
this
is
is
not,
not, this is not a sale.
this is not a sale, Your Lordship. So challenging consequential order without challenging the passive order, Your Lordship, on that.
No, but there is a challenge to the proceeding.
No, the registration of the case by the locata on the ground that locata has no jurisdiction.
What is this? Come to page number 16 of the writ petition.
Yes.
There is an order 28/1/2021. So this is a different order.
This is a different order. This is a different order.
Annexure M.
Page 35. Where locata has decided to proceed with the.
Okay.
Yes. So this order has not been challenged, Your Lordship, and that is why my third case law which I placed before Your Lordship.
This order is available in page 41.
Page 41. So the third case law, Your Lordship.
Yes.
2010, volume 1 SEC, page 756, para 22. Lordship has noted.
No challenge to basic orders.
Lordship, on that. So in my respectful submission, Your Lordship, the
Yes.
So just to sum up, Your Lordship, my full submission, the complaint in question, Your Lordship, it involves both grievance as well as allegation. There is an overlapping of grievance and allegation, Your Lordship. And what is barred under section 9(1)(a), Your Lordship, exclusive. Only complaint involving grievance, Your Lordship. So since the complaint in question involves both element of grievance and allegation, locata is not part of investigation. Therefore, locata has not committed any illegality in registering the case and deciding to proceed with the investigation. And Your Lordship, and there is no illegality in making the internal recommendation by the locata, Your Lordship.
So according to you, what is barred is only those in the nature of grievance.
Grievance, complaining about that is very specific, Your Lordship, because it cannot be expanded, Your Lordship. What is the can either be deleted nor expanded. So what is barred is only complaining grievance.
Yeah.
Lordship, my Lordship.
But we were expecting some more citations on these issues.
The provision is very clear, Your Lordship.
Therefore,
Yes.
it may be clear to you, but we need to have a, we need to crystallize on this clarity.
I tried my best, Your Lordship, more and then, and.
I don't indicate either you in your position as an additional AG or Mr. Jamir.
I have no more additional AG.
All right, former additional AG. And or Mr. Jamir as a senior counsel, but I find a lot of young people there. Maybe you can impress upon them to do some research and come back.
And Your Lordship, in so far as this case is concerned, Your Lordship, my submission is not adversarial, Your Lordship. Because this jurisdiction is not only about Nagaland Lokata Act, Your Lordship, like all state Lokata, even including Assam state Lokata, Your Lordship. All state Lokata has similar provisions.
So you're putting the court to a caution.
No, Your Lordship. I am just within my position clear. I am not adversarial, Your Lordship.
Right.
And Lokata, Your Lordship, the institution has been created to investigate into allegation, Your Lordship. If allegation cannot be investigated by the Lokata, then.
Yes, sir.
Much obliged.
Now, rules for the state.
Lordship, we have issued those in the as the incident is why. That's
Yes.
that is an
Now, what has happened to the inquiry?
Lordship, since the letter is subject we should not proceed with this.
We permit you to proceed.
Yes, but right now we have no possibility.
No.
So, Your Worship, page 51, the issue of notice, whereas the private case has been established for your act of gross misconduct in submitting effect regional of education in certificate issued by CSGMU, the consequence of which you are well aware of. And whereas there is reasonable ground to believe that you have utilized that means and misled the government and believe unto service benefits.
No, but what is the point in referring to the show cause? You're not proceeding with
Okay, if that is the case, Your Worship,
the allegation against you, I mean, vis-a-vis the petitioner, is that you acted too soon.
Yes, yes.
You acted on the interim recommendation of the Lokayukta. When the inquiry against departmental proceeding against the petitioner
was started after the inquiry conducted by the law Ayota. The inquiry conducted by the law Ayota was in the year 2020, and the issue was noticed by the department.
Was there any notice issued to the petitioner before the Lokayukta? Was he represented? They have issued, you appeared?
Yes.
Okay, no, just a query I'm asking you. You have been given notice, you have been put to notice.
Lordship, the certificate produced by the petitioner whereby he revealed the service benefit was a fake certificate.
That is for you to decide.
So
But you have not proceeded to decide.
Okay, Lordship, so we act on the interim recommendation of the law or not, that is the prerogative of the department, the state government.
No, but then.
So we have acted on it.
No, see, if you have acted, then the inquiry is meaningless. The show cause notice which you have issued is meaningless. If you have already acted.
Because it is not the final order in question. That revocation was only for the time being till the final recommendation was given by the law and the So your worship, it is not final, and we can always go ahead with the report. And whether to act upon only the recommendation or not, that is take the class. So the petitioner, he being producing the birth certificate itself is a great misconduct.
No, but where is the finding that it is a false certificate?
Worship, here, right now, in police, he also included in his, reply, worship. Which, 53, the motion of the legal. This is the reply by the petitioner.
To your show cause.
Yes, to our show cause.
But in the in the proceedings, you have not you have not.
We have not proceeded to worship.
Then-
Right now, we have, taken the.
So you have taken the interim recommendation.
Yes.
In the recommendation, is there a finding? that
Yes, yes, motion that is at page 53. As regard the gate certificate produced by Sri Wire, it has been verified from the Gauhati submit G. Maharaj University Company, Uttar Pradesh, and the same university has confirmed that gate certificate so produced by Sri is not Gmail. Yes, and then your worship, this has not been challenged by the petitioner. Then your worship may come to the affidavit in opposition by the private respondent.
Where is that affidavit filed by the petitioner before the Lokayukta?
That is at page 37. Page 37. And page 37. The relevant will be at page 37. Page 37 of the petition, the motion, this is the activity filed by the petitioner before the book and the relevant is at page 33, paragraph 4. Paragraph 4. That regard to the statement in paragraph such and such, the order is such and such, but by the honorable Kupal of Kohima, the document is to say that this CSMG University does not provide corresponding course, nor does it impart the same education. So the document to take this degree as a private degree, which is also unique in the degree, since the university is one of the oldest universities in the country. The document pursues the degree in full faith, and the question of faith or fraud of the document does not appear to me, and for which I submitted the document on completion of the 2 years. Then your lordship, page 39.
No, does he admit it is a false document?
Yes, page 39 here.
Yes.
Page 39, paragraph 7. That the document was made to go for obtaining this course from the 2 university because controversy arose on the genuineness of the CNG university.
No. Let us understand the position clearly. One is a situation of a false certificate.
Yes.
That means the certificate is not genuine, not issued by the university.
Yes, the verification given by the university has clearly stated that it is a tax certificate, your lordship. That is at page 52 of the private respondent affidavit. From the university where the petitioner said he obtained the PH certificate.
50?
Page 52
52 of the writ petition.
of the private respondents affidavit.
This
is from Chhatrapati Sambhaji Maharaj University, Kanpur. To the Office of the Inspector General of Police and Director, Landownership of Ayutthaya Police, Landownership, subject regarding educational qualification. Madam, in reference to your letter number such and such, letter 37/2020, the subject cited above, the required information regarding the details of result of verification for the following candidates is given below. Name, why would you know some now? Exam, BA, roll number such and such, year 2016. Marks obtained, result division, not genuine. signed by the controller of examination. So it is a fact certificate. And in the affidavit, the petitioner also tried to twist to evade
What are the private respondents? 5 to 9, no?
yes, okay.
Yes.
The findings, the
This is not disputed by the petitioner. In the,
No,
any reply evidence?
No. Second. So your worship, the law, I haven't found the entry documentation that the certificate produced by the petitioner is effective. So we acted upon it and we have issued the
What have you done? You have reverted him back.
limited back because as per the Nagaland Service Education Service Rule 2002, BA qualification is a prerequisite to hold the post of principal.
But he claims to have done some other course.
So that also is still under investigation. So the final recommendation will be come out by the law after verification of.
He's done 2 BA.
Yes, he obtained to be in order to improve his career.
One genuine, one not genuine.
What are under dispute, your worship? So there is nothing illegality, your worship, in revoking the officiating promotion when the petitioner does not have the requisite verification. That is my standing.
Where is that order of revocation?
Worship, that is page 66 of the recent.
66.
Yes. The last page. This in pursuance of the interim documentation such and such, and concurred by the PNR and the Law and Justice, the officiating promotion in respect of the petitioner from postgraduate teacher to principal by such and such is hereby revoked with immediate effect, subject to the final recommendation order of the Nagaland of Anita, Directorate of Investigation, Nagaland. So, your worship, my prayer is that the petitioner is not make out a case for interference of this court to interfere with the order passed by the authority on 24/3, that is revoking this officiating.
Yes. We'll continue tomorrow for your reply if you want.
Revising the division page, lordship can constitute single.
No, it's already constituted. There are some other matters. You request somebody to be present only for reply.
Submission has already.
If you have something more to say, we'll take it up day after or something. Dispense or recorded. All right.
Submission tomorrow.
You are for 5 to 9. Okay. Counsel for the petitioner is concluded with his right to reply, reserving his right to reply. So learned counsel appearing for Mr. Jamir, appearing for the Lokayukta, respondent 4, has also concluded his arguments. As also learned senior government advocate, additional AG, sorry, additional AG appearing for the government has also concluded their arguments. Matter be listed tomorrow for further hearing.
For hearing, item number 35.
This one. Hey, this you can give it back. Staple it and put it here somewhere. We'll continue. Yes. Item number?
35 million.
35, yes.
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 There was a battle last week regarding our resignation.
Resignations. Okay.
We got a provision of resignation. Which was for the in the school education service rules and service rules.
Service rule is silent.
Requested me to go to the provision regarding the resignation in the fire. Which means the fire also is silent.
Central FR. There's no FR separately for Nagaland. Have you adopted the Assam FR, sir? Central.
I have one more section.
Give it. Paragraphs?
11, 12, and 16.
Yes.
Even otherwise, the petitioner was asked to continue the service in the district statement of this petition. However, he did not agree with the piece of the respondent after 12, 11, and 24. In view of the above, the petitioner had voluntarily abandoned the service of the respondent. There was no requirement on the part of the respondent to ask any whatsoever of this petition. And it is a clear case of voluntary abandonment of service and the petitioner unable to be dismissed. Well, it is a settled law that an employee cannot be termed as a slave. He has a right to abandon the service anytime voluntarily by submitting his resignation and alternatively not joining the duty and beginning to absent the job. Absence from duty in the beginning may be police standard, but when absent is for a very long period, it may amount to voluntary abandonment of service, and in that eventuality, the board's service comes with an end without requiring any order to be passed by the employer. 16. In CPK, there was staff association and Aligarh Muslim District was Mansoor Aligarh. This board ruled that if a person is absent beyond the prescribed period for which leave of any kind can be granted, he should be treated to have resigned and cease to be in service. In such a case, there is no need to hold an inquiry or give any notice as it would allow useless formality. The lordship, the facts of the case here is a very brief. It will be at paragraph 4. The petitioner completed 20 years of service on such and such. He was promoted as deputy general manager on such and such. The petitioner submitted an application seeking PRS. The petitioner was informed by such and such that he should continue in service till the time
Till the time decision is taken.
Yes. However, the petitioner did not attend the duty after such and such. The petitioner joined the service of Buddha Limited, and as he did not go to the respondent to work on such and such, and there has been no response from the respondent, we filed a petition for issuance of the writ nonetheless, directing the respondent to accept the petitioner's application for voluntary retirement. Here in our case is to accept this resignation. During the pendency of the same petition, the petitioner was informed by respondent of the possession right that his application had been rejected. Thus, the writ petition filed by the petitioner that become unpracticed and the petitioner prefer another writ petition challenging the order dated second side. The respondent contested the state petition and during the pendency of the state petition, the petitioner attained the age of superannuation, that is 50 years as of such a son. The learned single judge dismissed the state petition filed. Agreed the writ petitioner preferred to read appeal, which has been dismissed by complete judgment and order hence this writ petition. So your worship, here the prayer of the petitioner is that he submitted a voluntary retirement, asking the respondent employer to accept. Then he joined the PIDA. The respondent has not communicated of his acceptance, for which he filed a writ petition before the court seeking the acceptance of his VRS. But the court says that when he abandoned the service, there is no formality for the employer to give any formal notice.
Now here, when did he submit his resignation?
31/10/2017.
31/10/17.
Yes, with immediate effect, your lordship, without any future.
Immediate effect.
Yes.
Where is that resignation again? Page number?
Which now with your lordship. This is the types of thing that the original one is page 19. To the principle of the federal basic issue. As cited in the subject mentioned above, I would like to request your opportunity for consideration. That's I have been appointed as VP and government primary school, suing me on such and such. That's to my own personal reason and temporary resignation from service. Therefore, I would like to request your to kindly accept my resignation from my service. Very well, thank you. So this is with me.
Then what happened? When was he? It was forwarded, isn't it?
Yes, it was forwarded to me. Page 21. Page 21. There is one petition.
Yes. This was on the same date.
Yes, this was one.
Then this was issued on which date?
This was submitted on 30/2/2021.
Hmm?
33.
33 what?
33.
33. Okay. Then
One but see, the thing is of water, the petitioners application for control. It's on 6/4 to be.
Then,
The acceptance was on 10 November 2022, page 24. This is initial application. This is the initial application, tendering resignation, page 90. It is a request. With a request to accept my, with a request to accept my resignation.
yes.
In this request for resignation, it will.
From which date did you submit resignation?
31/10/2007. The resignation was became effective upon the acceptance of this by the authority.
Sorry,
The resignation would become effective upon acceptance by the authority.
yes.
So obviously, these are prospective application, prospective resignation. It says this is subject to approval or acceptance by the authority.
So you have withdrawn the resignation
Yes, okay, I reform on 33/2021
before acceptance.
before acceptance.
Yes,
We can allow to rely on that's only one paragraph of the judgment which I cited right.
you have cited earlier.
2019, 2019-17 ACC.
Yes, yes. Air India,
Yes,
paragraph 11.
para 12. Para 11 is a lengthy paragraph here. The fixed court decided several judgment passed on relocation. In the findings has come on para 12.
Yes,
So paragraph.
yes,
Para 12, each 11144.
yes,
It is thus well settled that normally, until the resignation becomes effective, it is open to an employee to withdraw his resignation. When would the resignation become effective? It depends upon the governing service regulation and all the terms and conditions of the officers, as stated in para so and so and so and so so and so. In the absence, which is very important, in the absence of anything to the contrary, in the provisions governing the terms and conditions of the office post, or in the absence of a legal contractual constitutional part, a prospective resignation can be withdrawn at any time before it becomes effective. On this line and anything else. Further, as laid down in so. If, however, the administration had made arrangement acting on its resignation or letter of retirement to make other employees available for his job, that would be another matter. That issue is not on this. But she was rightly pointed out, before the authority accepted my resignation, I did it by withdrawal.
yes.
And in my initial resignation letter is a prospective resignation, requesting for acceptance. the resignation letter of the petitioner is plain and clear, saying that I'm resigning in this day. Can you accept my resignation?
You are relying on one judgment, is it? You are relying on a judgment. Yes, yes, yes.
That.
One minute.
The judgment led on my benefit is not dealing with it. In the first judgment, he has requested for resignation with an effective date.
Right.
And in the judgment of the past, which has been relied on the, in that case, the issue is no order has been passed, accepting his resignation. That was the challenge. So the tax board has come to a conclusion that when he has joined another post, passing an order of acceptance does not arise. That is a fine. The judgment, two judgment relied on by little friend is not really.
What are you doing since then?
My salary has been stopped.
No, but what are you doing? Are you in business or in, I mean, how are you surviving? You must give a reason how you are surviving.
Due to some family compelling circumstances, I've submitted my resignation.
That we have understood, but you have submitted resignation, you did not get any salary. So how are you surviving? Are you in business? Are you employed somewhere or what?
I'm not in.
Then you have to make a statement how you are surviving, doing what? You can't be, it cannot be that there is no source of income for all these years, 2017 to 22, 5 years. How have you survived? There's no money. They've stopped everything. Have you released this pension?
No, everything has to be.
Then-
If the Indian order is allowed to stand, all the machinery benefit of the people.
Yeah, but you, that's what we want to know, that where have you started? What have you done for all these years? Who has relied on Rajasthan state electricity? You have relied.
Yes, I rely on the distance it. GS.
Okay.
The response statement is one is entirely together with practice.
The petition requested to release him with an effective date.
Which paragraph is that? 3 to 6. Yes. That's all? 2000 volume 5. 2000 volume 5 SCC 621.
Para 5.
Para 5. Yes. Tell us. No, for what purpose? Voluntary retirement.
Procedure also voluntary retirement, but at this point, I see that voluntary retirement and or resignation. That in spite the tax can be withdrawn before the effective date. This is voluntary retirement or resignation.
Okay.
Before acceptance, it can be withdrawn.
All right. Heard learned counsels for the parties, arguments concluded, judgment reserved.
For hearing item number 45.
Have to staple this properly. Yeah. Yes.
Maybe it's not just there, right? Base one judgment. This one language. This
What-
was
what-
also similar lines.
What is your method?
My matter is, my lord, I'm challenging the commissioner appointment within this.
Compassion and.
Yes, yes.
Where is the judgment? Yes.
Paragraph number 30, amicus. Page 18.
Paragraph 30.
Yes, sir.
30.
Please, sir.
Yes. Hmm. Yes.
Lord, this court finds the Indian addendum dated such and such, which provides two more provisions, namely the compassionate appointment made to Group C and Group D posts under the scheme shall be strictly in order of date of death, and first preference shall always be given against those who have died earlier and who fulfills all other eligibility criteria, and the responsibility of completing the application forms of the next of kin of the deceased shall be with the department as per the prescribed format to be a reasonable one, and appears to have been issued in order to fill up the gap in the revised scheme dated 1909-2015. Not here. However, the manner of implementation of the provisions of the addendum in the present case is unacceptable and needs to be deprecated in as much as in the name of implementation of the said addendum, this has been prepared whereby strangely the kin of persons who have died in 1991, 1996, etc. have been allowed to submit the applications in the year 2022, which is evident from the record resulting in the deprivation of the genuine deserving candidates like the petitioner. So my lord, my case is also just on the fact that the process of implementation of the scheme has not been a proper one. My lord, next I want to take my lord to paragraph number just 36 and 37. The direction.
2 minutes. No, let us understand what happened to your case. You applied,
Yes.
then what happened? Your number was placed at some
733.
33.
Yes, and the impugn list was also, by way of the compliance letter, the impugn waiting list was also issued to me, which is an actual K1. Whereas on perusal of the.
Page number
page
35.
number 34.
Yes, 35 is your name.
Yes, serial number 35, whereas in the compliance letter, they have said, I'm at serial number 33, but there's no issue regarding that.
Okay. Now, you are agreed by this.
Impugn list, first of all, impugn list, because they have inserted names who are keeping in mind the object it seeks to, the scheme seeks to.
No, your date of expiry
Yes, my lord.
was
2020.
Yes, 2020. So I don't see any person in 2020 going up above you. I mean, the date-wise, dates are mentioned chronologically.
Yes.
Then,
The date wise, chronologically, that is there.
Right.
But my humble submission is that those who did not even apply, even after a gap of 17, 12 years, such as number 1 and 2, should not have been in the list. That's what our case is.
such as 1 and 2.
Serial number 1, serial number 2 have applied after a gap of 8 years. And for whatever reasons, number 3, no serial number has been given, but then he also applied after a gap of 12 years, and only application was only received only in 2023.
But you have to arrange as a party. Supposing you are challenging this person with no serial number. This appears to be out of place. His date of application was in 2023.
Yes, my lord.
Whereas 33/2023.
Yes.
Which is, no, sorry. 33 is your application.
33 is my application.
And his application is 16/6/2023 after your application. This person without no serial number.
She applied 16/6/2023. Mine is actually my not 2022.
Huh?
No, 2020. I applied 11/06/2020. In fact, but they have inserted 30/03/2023. I have also raised objection on this one also, my lord.
Where is
My
that?
first application was on 11/06/2020. It was forwarded. Let me take my lord to my first representation. It's at page 25.
Yes.
And it was forwarded on 11/6/2020 by the department.
This 25 does not contain any date.
I have said yes, my lord, but then the next page,
Yes.
my lord, the type of base at 27, page 27, my lord. This was, my application was duly forwarded on 11/6/2020.
Where do you find the date?
Date on the right side, my lord.
Right side, there is no date.
No, my lord, the next page,
Okay.
26, the forwarding of my application, since the application doesn't have date.
No, this 25A is what? Type
25 is my first application,
type copy.
25A is the type of.
Okay.
And page number 26 is the forwarding letter issued
In 2020.
in 2020, 11/06/2020. But then
Does it reflect the?
in the
Uh,
queue list. And
no,
even in
no,
the
no,
first
no,
waiting
no,
list,
no, does it reflect the application when you file the application?
the letter did not reflect when I applied.
All right, then.
So in the queue list, they have not, they have only indicated the the date of my second
Then
representation.
you filed some application,
I
representation.
representation subsequently, before approaching this honorable court.
Then what happened?
Then I approached this honorable court by way of filing the petition number 60 of 2023, which is at page number 30, my lord. Now, by way of a speaking order, this writ petition was disposed of.
Directing
With the
the
direction to dispose of my representation, my
Representation.
fourth representation, 11/6/2020, 14/3/2023. Then, page number 33. Page number 33 is the compliance letter that was issued to me along with the waiting list.
And then you applied for some RTI.
Yes, subsequently I applied some RTI.
So what did you get in the RTI?
In the RTI, page number 40 is the appointments made from 2018 till date. So here, 195 grade 4 appointments have been made without replacement.
No, these are not compassionate appointments.
These are not professional appointments. What I'm trying to project is, my lord, is from 2019, 20, 21, 2022, there has been no commissioner appointments whatsoever, my lord, despite the existence of the scheme. Whereas they are appointing so much of, there are, in fact, here 195 posts have been appointed up from 2018 till date.
Have they filed any counter?
They have filed a counter, but no clarification has been made in the counter, my lord.
Yes, government, what do you say?
This development was made till date, Lordship, till the time of the petition. And this 30% we are going on convention plan discussion.
No, he has made a statement that there was no compassionate appointment for one particular period of time. But you have continued to appoint direct recruitments.
Page 47 is the conventional appointment list. 2018, they've made 3 appointments, the rest all 2023.
What do you say?
These are all the requirements, conventional requirements still being negotiated in the final office petition. 195 was wanted on general temporary version.
Why do you say, you said for which year no compassionate appointment?
2019, 20, 21, 22, 4 years now. 4 years.
But in 23,
They have made some appointments. But here also, Lord, serial number 4, 5, 7, 10, 16, 26, and 30. With respect to this serial numbers, this persons did not appear in the first first waiting list prior to their appointments.
But you're not challenging their appointment.
Of course, my lord, that is admitted. I'm not challenging because since it is a compassionate appointment scheme, my lord, since they are also in the same position as I am in financial distress, my lord.
What is your prayer?
My prayer is simply, my lord, just interfere with the waiting list and direct the respondents to come up with a fresh waiting list, my lord. To that extent, my lord.
But there is only one instance.
Yes.
Government, what is your response to these waiting lists at page number 34?
Lordship, these are maintained by the departments in chronological order, Lordship, and as per the seniority. And because of the addendum, Lordship, there has been, the petition is saying that, there is allegations that his serial number was 33 before, and it was again shifted to 35, Lordship. But Lordship, because of the addendum.
Now see, come to this person at serial number 3. I mean, there's no number here, just before serial number 3. This gentleman, his father or relative expired in 2011. He filed the application on 16/6/2023. Right.
And he was only 11 years of age.
Then, as per the addendum, how are you to maintain the seriatim?
According to the date of death, Lordship.
Date of death.
Lordship.
Okay. But in your case, the principle governed in N. Santosh should apply. See, these are, unless you challenge a person's appointment, we can't find any reason to pass an effective order because these particulars are not here. Your serial number at 33, let us say that page number, what is that page number? Page number 34. This person without a serial number, for us to challenge it, that you have to make him a party. That you have not made a party. But his father expired in 2011 compared to your father having expired in 2020.
And just my own premise is that since there is no, the process, the way the department is implementing on the pretext of the addendum, the way they are implementing the policy is not as per the object, the schemes.
You have to show us the instances and put them to challenge. Only then we can interfere. Otherwise, how do we interfere? How do we interfere?
Put it this way, if I may put it this way, I am not agreed by the decision per se, but the way the decision making process. If that can be interfered by way of.
No, how can it be interfered?
Directing the state respondents to come up with a fresh waiting list, if they feel that.
You have to tell us what is wrong with the present waiting list. What is wrong?
Madam, I pointed out that this few individuals which should not have been in the waiting list. Their applications are kept in the waiting list.
So
you have
to give descriptions in your writ petition, making specific averments against that.
If, Madam, I may take it to paragraph number 10 of my.
Yes.
Writ petition. Just that is the crux of my petition.
Yes.
If I may be. That on perusal of the documents furnished by the department through RTI reply, it is apparent on the face of the report that there is clear manipulation in maintaining the list and there is discrimination in the appointment process, wherein the respondents have picked their candidates as per their whims and fancies, clearly violating the provisions of the scheme dated 1917-915. The manipulation by the respondents are quoted herein below. Number 1. On a comparative perusal of RTI reply dated 14 April 2023, which is Annexure M, and conventional appointment made in NPWD with effect from 2018 till date, Annexure L3, it is clear as number 5, 8, 9, 12, 16, 17, 21, 22, 35, 49, 42, 43, 50, 52, 53, 54, 56, 62, 63, 66, and 70 in the 14/4/23 days have been appointed without adhering to the provisions of the scheme, more particularly clause 11 of the addendum dated 9/4/19. The appointments are not made serial wise.
How do you say that? On the RTI, where is the
Yes.
RTI reply?
The first RTI, Madam, the first is Annexure M, Madam, page 48, and the list is at page 50. Yes.
Yes.
Here, serial number 5 was appointed. As per Annexure L3, serial number 8 was appointed.
No. Come to page number 48.
Yes.
Yes, you are referring to 48, isn't it?
I'm referring to 48. This is the RTI reply. And then the annexure is at page 50.
Yes. Then?
Serial number 5, my lord. Serial number 5 has been appointed. 8 appointed. 9 appointed.
Serial number 5, then?
8.
Read the name.
Name is Shri Iten Popi. Iten Popi. Number 8. Number 9, Shri Tiatunchen. Serial number 12, Shri Kumtilong Usagum. And next page, my lord, serial number 16. Shri Saroli C sometime. The third one. 16, serial number 16. Shri Saroli C sometime. Shri, next is serial number 17. Shri Atsung Jongar. Next is serial number 21. Srimati Vinika Jishi. Next is serial number 22. Srimati Lanu Sanla. And the next appointment is serial number 35 on the next page, page 52.
Yes. Name?
Srimati C. Ayung Pong, cell number 35. C. Ayung Pong.
Yes.
And down, cell number 40, my lord. Srimati Yantung Lokitan.
Yes.
And next, cell number 42, Srimati Krishnaro. And next, cell number 43, Srimati Ashuri Ofulia Muchin. And next appointment is
Wait. I can't find that name.
the last one, my lord.
This is,
Ofulia Muchin, cell number 43.
okay. That is all right, appointed.
Yes, my lord.
Okay, then,
And the next one is page 53, cell number 50,
name?
Meridam B. Chumoy. Cell number 50, Meridam B. Chumoy.
Yes.
Then cell number 52, Intitushi.
Hmm.
Then cell number Demrojong, cell number 53, Demrojong Z.
Hmm.
Next is 54, Chubar Najamir. Next is cell number 56, Mara, Upang Lang Bakung.
Their names are not there in the serial list, seniority list.
This is a seniority list.
This is the seniority.
Seniority list. What I'm trying to say is they are not being appointed as very attendant, that's serial wise. Now,
No, that serial wise, maybe they're not found suitable or something like that, because the posts are different, as you can see, grade 3, grade 4.
that very well, that might be the reason, but they, since we have raised that issue, they would have, in their, they're in opposition, they would have clarified, my lord. But no clarification.
All right, if you file your additional affidavit on this aspect, heard learned counsel for the petitioner, as well as the government advocate appearing for the state. The petitioner in the writ petition is essentially aggrieved. The petitioner in the writ petition is a contender for being appointed under compassionate appointment scheme. As who died your father? Father expired in the year 2020. Pursuant to his demise while in service, petitioner applied to the competent authority seeking appointment on compassionate basis. Stop. Since his applications were not considered, he approached his court by filing a writ petition, which came to be, where is the order? Earlier order. Page 30. Came to be disposed of by order dated 24/4/2023, passed in WPC 60 of 2023 by coordinate bench, directing the directing the respondents to consider and dispose of the representations filed by the petitioner dated 11/6/2020 and 14/3/2023 within a period of 6 weeks. Stop. In terms of the said direction, the respondents by communication dated 26th May 2023 passed an order disposing of the representations, holding that the name of the petitioner was at serial number 33, and accordingly, in terms of the seniority maintained by the department, his case would not be considered his case will be considered as and when his turn comes. So, pursuant to the said order, the learned counsel, the petitioner filed an RTI before the Office of the Engineer in Chief, NPWD, Nagaland, Kohima, Nagaland. Stop. In terms of the RTI, petitioner was furnished with certain information showing the names of all the persons on the compassionate appointment, furnishing a list of applications received for compassionate appointment under NPWD. Stop. Referring to the said list, learned counsel for the petitioner submits that I am unable to see your serial numbers because it is getting folded in the stitch.
I'm not in the first readiness, so that is where I'm also agreeing. They did not even consider me in the first.
Which is the first, page number 50.
Page number 50 is the first.
All right. Learned counsel for the petitioner submits that going through the list furnished under RTI, he finds that his name is not inserted there, although similarly situated persons' names were included in the same list. That apart, petitioner has given instances of persons at serial numbers. You give the serial numbers. First would be 5.
8.
5, 8, 9,
12.
12,
16.
16,
17.
17,
21.
21, 22,
35. 40.
35,
40.
40,
42. 43.
42, 43,
50.
52, 53, 54, 55. Sorry, 50. What is Merithum B. Jungyo? Page 50. Wait, 50. Then 52, 3, 4. 54, then 56. Yes. 62, 63, then
66, 67.
66, 67. Have been appointed under compassionate appointment, whereas stop. It is submitted that bare perusal of the seniority list stated to be maintained by the department reflects that appointments are not made in seriatim. Stop. However, the counter affidavit filed by the department does not reflect as to why the seriatim is not maintained. Whereas, learned counsel for the government advocates appearing for the state submits that she be permitted to file, she be permitted to complete her instructions, and if required, place it before the court by way of an affidavit. Let the matter be lifted after 2 weeks. Yes.
Right.